shall give their attention, for the court is now in session.
Attorney Richeta.
Your Honors, called for today's oral argument is the petition for certiorari and mandamus. Kindly be seated. Assailing the validity and constitutionality of Section 6 of Executive Order Number 811 and to command and compel the respondents to implement Section 32 of Republic Act 9173, otherwise known as the Philippine Nursing Act of 2002, docketed as GR number 215746, entitled Ang Nars Partylist, represented by Congresswoman LEAH PRIMITIVA, SAMACO-PAQUIZ, and the Public Services Labor Independent Confederation, or PSLINK, represented by its General Secretary, GERON, as petitioners, versus the Executive Secretary, the Secretary of Budget and Management, and the Secretary of Health as respondents.
Will you state the appearances of the parties?
Your Honors, the appearances are the following. As counsel for petitioners, Attorney Sharon Faith Paquis, please raise. Assisted by Mr. Mark Edmond Navarro. And for the respondents, the Office of the Solicitor General, Solicitor General Jose Calida, Assistant Solicitor General Marisa de la Cruz Galandines, Assistant Solicitor General Rex Bernardo Pascual, Assistant Solicitor General Hermes Ocampo, Assistant Solicitor General Joseph Guevara, and Assistant Solicitor General Diana Castañeda de Vera. That's all, Your Honors.
Okay, we will follow the sequence of arguments based on the advisory that was issued in this particular case. The Solicitor General, do you affirm that you have already communicated to the Congress, both houses of Congress, and that you will also speak for them, no? All right. The petitioner will now make the presentation. There is only one counsel for your side. All right. You may all sit down. The petitioner may now proceed. You have 20 minutes.
Good afternoon, Your Honors, Chief Justice and Associate Justices. I will argue 2 points, Your Honors. First, whether Joint Resolution Number 4 has repealed Section 32 of RA 9173 on the following reasons. 1, whether a joint resolution that followed the procedure of a bill passing into law is a law. And 2, whether Joint Resolution Number 4 followed the procedure of a bill passing into law. The second assignment of argument is on the issue of if in the event that the Joint Resolution Number 4 has not repealed Section 32 of RA 9173, whether the Supreme Court can compel the respondent to pay the nurses their salary under Salary Grade 15 as prescribed by Section 32 of RA 9173. Your Honors, with all due respect, the assigned issues exclusively deals and treats the procedural aspect of passing a law or a joint resolution and its effect in relation to joint resolution. The petitioner's position is that there is a need also to raise the issue of substantive aspect of whether Joint Resolution Number 4 expressly or impliedly repealed Section 32 of RA 9173. With the kind permission of Your Honors, As to the procedural aspect, the Constitution mandates in Section 27 that every bill passed by Congress shall, before it become a law, be presented to the President. If he approves the same, he shall sign it. Otherwise, he shall veto it, and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to consider it. The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof. Otherwise, it shall become a law as if he had signed it. Thus, Your Honors, in order to become a law, a Republic Act legislated by Congress, the Constitution mandates that it must originate as a bill. Legislative power is the power to create and enact laws. And as stated in the book of Associate Justice Isagani Cruz, the power of lawmaking is effected through the adoption of a bill or a proposed or projected law, which once approved becomes a statute. In return, a statute as defined in the Black's Law Dictionary is the written will of the legislature solemnly expressed according to the forms necessary to constitute it the law of the state. The process on how to become a law is likewise laid down in Article 6 of the Constitution, where in Section 26 thereof states that every bill passed by Congress shall embrace only one subject, which shall be expressed in its title thereof. Given the foregoing constitutional mandate on the process of legislative enactment of a law or statute, joint resolution is clearly out of context. There is no saying that joint resolution, even though it passed 3 readings of both houses approved by the President, will make it a Republic Act, according to the forms necessary to constitute if the law of the state. And even assuming that a joint resolution can become a law, joint resolution failed to comply with the constitutional requirements that every bill shall embrace only one subject, which shall be embraced in the title thereof. While the title of joint resolution is a joint resolution authorizing the President of the Philippines to modify the compensation and position classification system of civilian personnel and the base pay schedule of military and uniformed personnel in the government, and for other purpose, it, however, repealed numerous laws in item number 16 thereof. Thus, in the case of Philconsa versus Jimenez, it was settled that the constitutional requirement that the subject of an act shall be expressed in its title should be reasonably construed so as not to interfere unduly with the enactment of necessary legislation. It should be a practical rather than technical construction. It should be a sufficient compliance with such requirement if the title expresses the general subject and all the provisions of the statute are germane to the general subject. On the other hand, the joint resolution was merely interjected in the internal rules of the congressional houses. In the House of Representatives, it was stated that a joint resolution having the force and effect of law goes through the same process of resolution, or rather goes through the same process of passing a bill. In the same manner, the Senate of the Philippines enumerated the type of measures that Congress may consider and act upon. Well, in addition to treaties of the Senate, include bills and 3 kinds of resolution, 2 of which are concurrent and simple resolutions. Both are not referred to the President for his signature, and they do not have the force of law. Your Honors, allowed me to focus on the bill with comparison to joint resolution. As per Senate's website, it defined the bill that these are the measures which is passed upon by the laws, which are passed upon may become a law. The vast majority of legislative proposal, recommendation dealing with the economy, increasing penalties for certain crimes, regulation on commerce and trade, etc., are drafted in a form of bill. They also include budgetary appropriations of the government and many others. When passed by both chambers in identical form and signed by the President, or repassed by Congress over a presidential veto, they become law. On the other hand, A joint resolution, like a bill, requires the approval of both houses and the signature of the President. It has the force and effect of a law, if approved. There is no real difference between a bill and a joint resolution. The latter generally is used when dealing with a single item or issue, such as a continuing or emergency appropriations bill. Joint resolutions are also used for proposing amendments to the Constitution. It could easily deduce therefrom from the above rules of the Senate and House of Representatives that a joint resolution, when passed through both houses after 3 readings and later on approved by the President, has the force and effect of law, but it is not a law under the context of a Republic Act. In parallelism, Your Honors, executive orders, administrative rules and regulations, circulars, and other issuances of various governmental institutions are not laws within the ambit of Article 6 of the Constitution. However, since their intention is to give regulatory and obligatory effect to an existing legislative statute, they attain the status of having the force and effect of law. The wisdom of the phrase "has the force and effect of law" has been settled as early as 1914 in the case of United States versus Molina, wherein it said that the very nature of things in many cases, it becomes impracticable for the legislative department of the government to provide general regulations for various and details of management of particular department of a government. It therefore becomes convenient for legislative department of the government by law in a most general way to provide for a conduct, control, and management of the work of a particular department of the government. To authorize certain persons in charge of the management, control, and direction of the particular department to adopt certain rules and regulations providing for details of management and control of such department. Such regulation have uniformly been held to have the force of law whenever they are found to be in consonance and in harmony with the general purpose and object of the law. In application, Your Honors, Republic Act Number 6758 was enacted in August 21, 1989. It sets the minimum standard of salary of nurses to salary grade 10. In 2002, Republic Act 9173 was enacted, whereby the salary grade 10 of entry level for nurses was repealed and a new salary grade 15 was instituted in Section 32 thereof. Thus, only a law can repeal a law, Your Honors. On the sub-issue on whether a joint resolution that followed the procedure of a bill passing into a law, our position is in the negative. The mere fact that a joint resolution followed the procedure of a bill passing into law does not make it a law. Our Constitution has clearly defined the metes and bounds of a legislative powers to enact laws. Thus, Constitution dictates that no bill passed either house shall become a law unless it passed 3 readings on separate days. The use of the word bill by the framers of the Constitution is not in vain, but a well-thought act that will confer and limit the powers of the legislature. Section 24 thereof enumerates the bills that can ripen into law upon compliance with the stringent legislative process, to wit, all appropriations, revenue or tariff bills, bills authorizing increase of public debt, bill of local application, and private bills shall originally exclusively in the House of the Representative, but the Senate may propose or concur with amendments. From the above enumeration, we can never see the word joint resolution. Culminating from the basic principle of statutory construction, it was repeated in the case of Centeno versus Villalon Cornelius that the express mention of one thing, act, or consequence exclude all others. Where a statute by its term is expressly limited to a certain matter, it may not by interpretation or construction be extended to others. The rule proceeds from the premise that the legislature would not have made specified enumerations in the statute had the intention been that to restrict its meaning and to confine its terms to those expressly mentioned. In fact, Your Honors, it could be gleaned from the archives of the House of Representatives during the period of sponsorship and consideration of the House Joint Resolution number 36, or the now subject Joint Resolution number 4, that even members of the House treat joint resolution as inferior from a law. Congressman Rodriguez raised the following issues in the said proceedings, wherein he said, Mr. Speaker, my question is, will this Joint Resolution number 1992 under committee report prevail over the express provision of a law that mandates that nurses should have a salary grade 15? The sponsor, Representative Kua, answered, Mr. Speaker, a joint resolution is a resolution that is supposed to be passed by both houses and signed by the President. And from my understanding, this joint resolution, if it passes the scrutiny of both houses and signed by the President, would have the force and effect of a law. And I think there is jurisprudence to that effect. And so that being the case, if having the force and effect of law, it could amend that act. In response, Representative Rodriguez replied that, Mr. Speaker, the reality is we are losing our workers in the public health sector. They have been going out of the country, and precisely because we have not been able to implement salary grade 15 under the Nursing Act. The solution is not to demote the salary grade from 15 to 11 by the mere expedient of a joint resolution, because I believe that it cannot amend a law. Joint resolutions are, according to U.S. jurisprudence, resolution in Congress for small matters that are taken up by Congress. In this case, there is already a law, the Nursing Act, that provides for salary grade 15. The solution would have been to increase the salary of doctors so that doctors who have labored so hard studying would be able to get their due compensation. On the other sub-issue of whether Joint Resolution number 4 followed the procedure of bill passing into law, with all due respect, Your Honors, upon my verification with the archives and records of the House of Representatives, we cannot determine by available record if Joint Resolution number 4 followed the entire process or procedure of a bill passing into law. The transcript of the Committee on Appropriations, in consultation with stakeholders, bicameral reports, and other pertinent transcripts were not made available. Only the following records were retrieved. Number 1, the transcript of the plenary proceedings held on May 18 and 20, 2009, during the period of sponsorship and debate. Message from the President of the Philippines certifying the necessity of the immediate adoption of the House Joint Resolution number 36 and consideration of the conflicting committee reports on House Joint Resolution number 36 and Senate Joint Resolution number 26 on June 1, 2009. It is then our first humble submission, Your Honors, that Joint Resolution number 4 is a resolution passed by both houses and thereafter approved by the President. Although it attained the status of having the force and effect of law, it does not, and it never attained the status of a statute or law within the purview of Article 6 of the Constitution. Being such, Joint Resolution number 4 is devoid of mandate to repeal or even alter Section 32 of RA 9173, which is a valid legislative enactment of law with full blessings of and total compliance with the mandate of the Constitution. Your Honors, allow me to go to the substantive aspect. In 2009, Joint Resolution number 4 was passed by Congress authorizing the President to modify the compensation and position classification system of civilian personnel. For one, there was no specific provision in the body of the said joint resolution pertaining to the specific repeal of Section 32 of RA 9173. Second, Joint Resolution number 2 is fortified with the provision on non-reduction or diminution of benefits and salaries. To construe that Joint Resolution number 4 has amended Section 32 of RA 9173 would run counter with the principle of non-diminution of benefits and salaries. As explicitly contained in Item 11 of Joint Resolution number 4, it provides that non-diminution is the basic salaries of incumbent employees. In no case shall there be any diminution in the basic salaries of incumbent employees upon the implementation of this joint resolution. For this purpose, they shall receive the new salary rates prescribed herein to be implemented in tranches, which is in no case shall be less than their existing salary rates. To construe otherwise will create constitutional issue on the guarantee of the state to protect the rights of workers, their welfare, and to afford full protection to labor as enshrined in Article 13, Section 3 in the Constitution. Third, the archives of the House of Representatives in the transcript taken during the Bicameral Committee meeting on these agreeing provisions of RA 9173 fortified the repeal of SG 10 of RA 6758 and increased the salary grade of nurses to 15, with the intention to modernize the practice of nursing profession and to institutionalize it through a valid and deliberate legislative act. Thus, borrowing from the language of Senator Angara, he said that if there was a hearing where the budget has been heard, no, there was no hearing because this particular provision was suggested and proposed during the plenary debate, and the chairman accepted that because it is really part of the modernization of the profession. And so, we thought that we need to seek prior views of the budget because this is not basically an appropriations act. It is incidentally. It's a provision that sets a higher entry-level salary for nurses as incidental to the overall objective of modernizing the nursing profession. So this is perfectly allowed under our practice. And secondly, I think this is most important. We all know that unless there is a legislative mandate, the budget will not move. The Department of Budget will never move, and we thought that such a mandate is now long overdue. Section 32 of RA 9173 provides that in order to enhance the general welfare, commitment to service, and professionalism of nurses, the minimum base pay of nurses working in the public health institution shall not be lower than salary grade 15, prescribed under our Republic Act number 6758, otherwise known as the Compensation and Classification Act of 1989, provided that for nurses working in local government units, adjustment of their salary shall be in accordance with Section 10 of the said law. Your Honors, if indeed it was the intention of the legislature to repeal Section 32 of RA 9173, it would have filed a bill specifically repealing the same and not merely by a collateral attack through the passage of Joint Resolution number 4. Pursuant to the mandate of Article 7 of the Civil Code, laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse or custom or practice to the contrary. Fourth point, Your Honor, Section 5 of Article 9B of the Constitution, under the provision of the Civil Service Commission, specifically delegated to the Congress of the Philippines the power to standardize the compensation of government employees. Section 5 thereof provides that the Congress shall provide for the standardization of compensation of government officials and employees, including those in the government-owned and controlled corporations with original charters. Taking this into account, the nature of the responsibility pertaining to and qualifications for their positions. If I may be allowed, Your Honors, I will now proceed to the second issue. Under Rule 65 of the Rules of Court, when a tribunal, corporation, or board unlawfully neglects the performance of an act which the law specifically enjoins as a duty from an office, trust, or station, unlawfully exclude another from the use and enjoyment of a right or office to which such is entitled, and there is no other plain, speedy, and adequate remedy in the ordinary course of law, the person aggrieved thereby may file a verified petition in court, alleging the facts with certainty and praying that judgment be rendered commanding the respondents immediately or at some other time specified by court to do the act required to be done to protect the rights of the petitioners and to pay damages sustained by the respondents, or rather by the petitioners, by reason of the wrongful act of the respondents. In the case at bar, it is an undisputed fact, and beyond the era of debate, that government nurses, represented by herein petitioners, are entitled for the enjoyment of salary grade 15, and its implementing rules and regulations from 2002, or the date of its effectivity of said law. However, this was never given to them. 13 years, Your Honors. Government nurses never have been deprived of their right to salary since 2002. And until present, the same is being denied to them. Section 32 of RA 9173 is a mandatory law, and non-observance and violation of a valid and existing law shall not be an excuse by disuse or custom or practice to the contrary. Thus, the respondents, it is significant to point out to the attention of the Honorable Court that the respondents' offices, DOH, DBM, and Office of the Executive Secretary apparently ignored and took for granted for a long period of time the implementation of Section 32 of RA 9173, notwithstanding the promulgation of implementing rules and regulations. In 2009, respondents contradicted themselves when it reduced the salary grade of nurses from 15 to salary grade 10. Notwithstanding the implementing rules and regulations of Section 32 of RA 9173. Sadly, the aforementioned provision of RA 9173 was neglected and was relegated into obscurity until herein petitioner PAQUIZ persistently raised or resuscitated the said issue. Given the more than 13 years suffered by government...
Counsel, you have 1 minute. Wind down.
Yes, Your Honor. Given the more than 13 years suffered by government nurses due to the non-implementation of Section 32 of RA 9173, petitioners were hopeless of any recourse and believes that there is no plain, speedy, and adequate remedy in the ordinary course of law. That's why petitioners petitioned the highest court to command the respondents to do the act required to be done pursuant to the Constitution. It is therefore our humble submission that the Honorable Supreme Court can compel the respondents to pay the nurses their compensation under salary grade 15 as prescribed in Section 32 of RA 9173. Thank you, Your Honors.
All right, the interpellation will be started by Justice Carpio, please.
Counsel, can you go to item 16 of Joint Resolution number 4? The second paragraph of item 16 of Joint Resolution number 4. Can you read it, please?
Amendment of existing laws. The provision of all laws, decrees, executive orders, corporate charter, rules, regulations, circulars, approvals, and other issuances.
Is that the second paragraph of item 16?
Sorry, Your Honor. All provisions of laws, executive orders, corporate charters, implementing rules and regulations prescribing salary grade for government officials and employees other than those in Section 8 of Republic Act number 6758 are hereby repealed.
So this provision says all laws, regulations prescribing salary grades other than in Section 8 of RA 6758 are repealed. So this provision reinstated the old Section 6 of RA 6758, correct? And under the old Section 6, the salary grade of nurses was
10. Your Honor.
10, correct?
Yes, Your Honor.
So if Joint Resolution number 4 is a law, then we are back now to Section 6, prescribing a salary grade of 10 for nurses. That's why it's important to find out if Joint Resolution number 4 is a law or not.
Yes, Your Honor.
You understand now why this is primordial?
Yes, Your Honor.
Okay. We patterned our Constitution after the U.S., correct? U.S. Constitution?
Correct, Your Honor.
And under the U.S. Constitution, what measures could be enacted into law? A bill could be
A
enacted
bill.
into law. What else? Resolutions. It's expressly stated in the U.S. Constitution. A bill, a resolution, a vote, and an order. 4 measures could be enacted into law. When we adopted our Constitution in 1935, did we adopt the 4 measures that could become a law?
We only adopted bill and resolutions, Your Honor.
Bill and resolutions. Are you sure?
Orders, I think, Your Honor. Yes, we adopted the.
When we adopted the 1935 Constitution, it was first a unicameral legislature, correct?
Correct, Your Honor.
And what did the 1935 Constitution prescribe as to what can become a law? Did it say bills or resolutions can become a law, or only bills? The 1935 Constitution only mentioned bills.
Bills.
Did not mention resolutions, did not mention
Orders.
orders or votes. So, but since we patterned our Constitution after the U.S. Constitution, can you say that we impliedly incorporated resolutions, bills, and resolutions, votes, and orders that could become a law in the Philippines?
No, Your Honor. It cannot be implied, Your Honor.
It cannot be implied.
Yes, Your Honor.
So we rejected all the other measures.
Yes, Your Honor.
We only adopted bills.
Yes, Your Honor.
Okay. So there was only one kind of measure that could become a law under the 1935
1987.
Constitution. We were then a unicameral legislature, one body only, not yet bicameral.
Yes, Your Honor.
So we became bicameral in 1941. We had a Senate and a House. What could become a law? A bill, a resolution, vote, or order under the bicameral legislature of the 1935 Constitution?
Bill, Your Honor.
Only bills. So, you cannot say that there was a clerical error because in the unicameral legislature, only bills, resolutions could not. And when we became bicameral, only bills, not resolutions, correct? There was no error.
Correct, Your Honor.
It just followed the procedure of the unicameral. Now, we go to 1973 Constitution. Was it bicameral or unicameral? 73, Batasang Pambansa. Unicameral. Correct?
Yes, Your Honor.
Under the 1970 Constitution, what could become a law? Bill, resolution, vote, order?
Bill, Your Honor.
Only bills.
Yes, Your Honor.
We were unicameral then. Resolutions could not become a law.
Yes, Your Honor.
1987 Constitution. What could become a law?
A bill, Your Honor.
We were already bicameral.
Bicameral, Your Honor.
When the Constitutional Commission were drafting the Constitution, members were drafting the Constitution, they initially thought of a unicameral, correct? It was a unicameral legislature that they were thinking. Bicameral won by one vote, correct?
Yes, Your Honor.
And even under the unicameral concept of the 1987 Constitution, only bills
Only
could
bills,
become
laws.
law, never a resolution. When the vote for bicameral won, they did not change it. It remained
A bill, Your Honor.
still a bill. Only a bill could become a law, correct?
Yes, Your Honor.
Now, what can the President veto? Can the President veto a resolution?
Pursuant to the internal rules of both houses, yes, Your Honor.
Under the Constitution, what can the President veto?
Only enrolled bills, Your Honor.
Only a bill can be vetoed.
Yes,
because
Your Honor.
only a bill becomes a law.
Yes, Your Honor.
Okay. And if it's an appropriation, he can veto what? Only a line item.
He can, Your Honor.
But if it's not an appropriation, revenue, or tariff bill, he can veto the entire. Okay. In the House of Representatives rules, it's stated in the rules that a bill can become a law, correct?
Yes, Your Honor.
And also a resolution can become a law.
No, Your Honor. It has the force and effect of a law. It's, I think,
Can you read
the way they frame it is different from each other.
Can you read?
As per Senate version, Your Honor,
No, I'm asking for the House. The House has its own rules, the
Yes, Your
Senate
Honor.
has its own rules, and they're not the same.
yes, Your Honor. In the House, they did not specifically mention the format of the rules of the House is the format of how a bill becomes a law. But at the latter part, at the
Can you
last
read
part,
it?
Your Honor, a joint resolution having the force and effect of a law goes through the same process of passing a bill.
Okay. So, under the House rules, a bill can become a law and a resolution can become a law, having the force and effect of a law.
The force and effect only, Your Honor.
So, if it has the force and effect of a law, can it repeal a prior law?
No, Your Honor.
Why?
Only a law can repeal a law. That is categorically mandated in the civil code that subsequent laws repeals prior ones, Your Honor.
So, a measure that has the force and effect of a law cannot repeal a law. That's your point.
Yes, Your Honor.
Okay, let's go to the Senate. In the Senate, what can become a law?
Only bills, Your Honor.
How about resolutions?
Will you allow me to read, Your
Yes,
Honor?
okay.
A joint resolution, like a bill, requires the approval of both houses and the signature of the President. It has the force and effect of a law if approved. There is really no difference between a bill and a joint resolution. The latter generally is used when dealing with a single item or issue, such as a continuing or emergency appropriations bill, and joint resolution are also used for proposing amendments to the Constitution.
Okay, so you're saying that under the Senate, a resolution that's adopted has the force and effect of law, but it cannot repeal a law because it is not a law. It only has the force and effect of law. It's
Yes,
like
Your
an
Honor.
implementing rule.
Yes,
Is that,
Your Honor.
yeah, because an implementing rule has the force and effect of law, but it is not law. That's your position.
May I clarify, Your Honor?
Yes.
It is not a stand-alone. It has to be dependent on something or a primary statute to implement or to modify it or to
In other words, a joint resolution like Joint Resolution Number 4, which implements a prior law, has the force and effect of law because there is a mother law.
yes, Your Honors.
Okay. Now, in the House, you go back to the House, what is the procedure for passing a resolution that has the force and effect of law? Does it require three readings on separate days?
Yes, Your Honor. Readings on separate days.
Can you read it?
No bill passed by either house shall become a law unless it has passed 3 readings on separate days.
That's exactly how a bill becomes a law, correct? Under
Yes,
the
Your Honor.
Constitution.
Yes,
In
Your
the
Honor.
Senate, what is the procedure?
It's the same, Your Honor.
You read it. How many readings does a resolution pass?
It's not, it is not categorically stated, Your Honor, but what has been implemented, what has been stated in the...
Can you read? There's a provision there which says 3 readings.
Yes, Your Honor. Same readings as a bill.
No, you read it again.
It's just say there's really no difference between a bill and a joint resolution.
Yes, but you go to the passage of a resolution, how many readings?
Your Honor, as far as I could remember, it's just the same because the wordings of the Senate uses the term bills or joint resolution, Your
No,
Honor.
you go. Okay, do you have it there?
I don't have the complete text of the rules, Your Honor.
It says, shall pass 3 readings. Read it.
No, Your Honor. It says a joint resolution having the force and effect of law goes through the same process of passing a bill.
There's a separate provision. It says it shall pass 3 readings, period. It does not say pass 3 readings on separate days. So a Senate resolution can be approved if it is read in one day, 3 times. It is not the same as passing a bill. When you pass a bill, you have to read it three times separate days. First day you read it, second day you read it, third day you read it. That's how you pass a bill on 3 readings on separate days. But for the Senate, it says pass a resolution on 3 readings. So you can do it in one day.
One day.
So it's not the same as in the Constitution, correct?
Yes, Your Honor.
Now, can the House change its rules anytime to say that a resolution shall be approved by only 1 reading in one day? Can they do that?
Yes, Your Honor.
Can the Senate also do that?
Yes, Your Honor.
Anytime?
Yes, Your Honor.
Okay, so, but can they also amend the rule that a bill has to be read 3 times on separate days? Can they say it can be read once only in one day?
No, Your Honor, unless they repeal the Constitution.
So, the Constitution prescribes how a bill is enacted into law. Very specific, 3 readings on separate days. But a resolution of the House or Senate, that depends on them. If it will be read in one day, or in 2 days, 3 days, 4 days, 5 days, it's up to them.
Yes, Your Honor.
And they can change that anytime, correct?
Yes, Your Honor.
Okay. The House, the rules of the House expire after every term of Congress, correct?
Correct, Your Honor.
Because Congress expires after
3 years, Your Honor.
So the next Congress will have to adopt new rules, correct?
Yes, Your Honor.
And if the new Congress will say a resolution can be adopted by just 1 reading, that's it, correct?
Yes, Your Honor.
So it will now differ from the procedure
Of the
for enacting bills into law, correct?
Correct, Your Honor.
How about the Senate? How long does the Senate rules
6 years, Your Honor.
continue?
6 years, Your Honor.
Now, under a decision, in the Neri case, they have to republish it every 3
3
years. Because
Of the transition, Your Honor.
there are only 12 senators left. That's
Yes,
not a majority.
yes, Your
So
Honor.
they have to republish it. That means the rules are good for 3 years only, correct?
Correct, Your Honor.
So that is the difference between a bill. You cannot change it. It has to pass through readings on separate days. But a resolution, the Congress at any time can change how it is passed, correct?
Correct, Your Honor.
Okay. Now, can this court compel, assuming you are correct, that Section 12 of the Nursing Act of 2002 has not been repealed because Joint Resolution number 4 is not a law, can we compel now Congress or the DBM to fund Section 12 of the Nursing Act? Do we have the power to compel Congress to appropriate funds for a salary grade 15 for nurses?
May I qualify?
Yes.
The highest court can compel the executive branch to implement the law, Your Honor. But insofar as appropriations of funds is concerned, it is within the ambit of the power of the legislature, Your Honor. So
But to implement the law requires funding.
Yes, Your Honor.
It requires appropriation because
Yes.
that's the only thing that's lacking.
Yes, Your Honor.
So in effect, when we say implement the law, we are really telling go to Congress and have this appropriated.
Yes, Your Honor.
Can we do that?
Yes, Your Honor. Because during the budget call, the executive branch of the government prepares the the salary of its employees, and if they propose it during the budget hearing to the Congress, for it to be appropriated with proper funds, and then the Congress of the Philippines can give the proper
So what you're
appropriation
saying,
for it.
because there is a law prescribing salary grade 15,
Yes, Your Honor.
we can compel, we can mandamos the DBM
Yes.
to implement the law. And DBM will have to go to Congress for the funding.
Yes, Your Honor.
But is Congress compelled to appropriate?
Yes, Your Honor.
Congress is compelled to appropriate?
No. Sorry, Your Honor. No.
So it's up to Congress in the end.
Yes, Your Honor.
So why do you come here? Why don't you go to Congress?
The same scenario, Your Honor. The petitioner here, Representative PAQUIZ, during the 16th Congress, asked the DBM, why are you not implementing, or why are you not asking the legislative branch of the government to fund salary grade 15 for government nurses? That's the very meat, Your Honor. The DBM said, we cannot do that, because it will bleed, strain, or drain the coffers of the government. That's why we are restricting the implementation of the salaries of government nurses to salary grade.
So you're saying Congress did not even propose, the DBM did not even propose to Congress?
Yes,
to fund
Your
it?
Honor. They implement salary grade. During the 16th Congress, there is
They never
already...
asked for funding for salary grade 15.
Yes, only salary grade 11.
So you're asking us to compel the DBM
Yes,
to
Your Honor.
include that in the budget proposal to Congress.
Definitely, Your Honor.
But you're saying it's up to Congress to approve it or not.
Yes, Your Honor, by virtue of the separation of powers, Your Honor.
Okay, that's all, Counsel. Thank you.
Thank you, Your Honor.
Justice Bernabe.
Okay. Am I correct to say that in your petition, as well as in the prayers in your petition, you did not assail the validity of Joint Resolution number 4?
You're correct, Your Honor.
So we can now presume the constitutionality of Resolution number 4.
Unless otherwise declared unconstitutional, yes, Your Honor.
Now, under the 1987 Constitution, it is provided that no bill can become a law unless it has passed 3 readings on the
Both
separate days. Now, is this constitutional provision exclusive to bills, or can it include any other matter such as resolutions if passed through the same procedure for bills?
For a bill to become a law, Your Honor, it is exclusive and mandatory, Your Honor.
But is the Constitution exclusive on this?
Yes, Your Honor.
Can you just read it once more?
No bill passed by either house shall become a law unless it passed 3 readings on separate days.
So to you, bill is exclusive. This constitutional provision cannot include any other matter such as resolutions, orders. It's only limited to bills.
Yes, Your Honor, that's the intention of the framers.
All right. Another question. One of the issues presented is that since Joint Resolution 4 provided for non-diminution of benefits and salaries, then respondent exceeded its authority in issuing EO 811. Is that correct?
Correct, Your Honor.
Now, when you say diminution of salaries and benefits, are you referring to salary grades or just the take-home pay of nurses?
It speaks of basic salary of incumbent employees, Your Honor.
So are you referring to the take-home pay?
Take-home pay, Your Honor.
Are you aware that the take-home pay of nurses 1 at the time of the effectivity of the Philippine Nursing Act in 2002, if you were to fix it at salary grade 15, is 11,000 for step 1 and 13,000 for step 8?
Yes, Your Honor, salary grade 10.
Okay. Now, at the time of the effectivity of Joint Resolution 4, which fixed the salary grade to salary grade 11,
Your Honor, it was Executive Order 811 who fixed the salary grade of nurses to 11. It was never the Joint Resolution number 4, Your Honor.
okay. But salary grade 11 has a take-home pay of about 18,000 for step 1
Yes, Your Honor.
and 19,000 for step 8. Is that correct?
Correct, Your Honor.
And therefore, if you are now to fix the salary grade of nurses at SG 11, the take-home pay would still be bigger than when it was before the passage of Joint Resolution 4.
Yes, Your Honor.
So,
Because of Executive Order 201.
So
Yes, Your Honor, sorry.
so would you now say that there is a diminution of benefits and salaries when the take-home pay has even increased?
Yes, Your Honor. Because what has been diminished is the salary grade, Your Honor. The salary grade increases every 3 years or every 6 years. It increases also by tranches. It increases also by level. Now, if we will be pegging the salary grade of nurses to salary grade 11, it could never be justified, Your Honor, just because of the enactment of Executive Order 201 pegging salary grade 11 to, I think it's 25,000 now. As compared to the salary grade 15, which is 30,000, there's still diminution, Your Honor.
Okay, so you're now changing your answer. The diminution of salaries and wages to you is the salary grade and not the take-home pay.
Can I explain, Your Honor? The salary grade is the position classification being given, but the take-home pay, Your Honor, is the monetary equivalent of the salary grade. So vis-a-vis, they are the same, Your Honor. They are the same. When you speak of salary grade 15, the monetary equivalent of salary grade 15 is 30,000, effective January 2019. But if you will say salary grade 11, the monetary equivalent of salary grade 11 is 20,000, Your Honor. So it's just the same. May it be salary grade, may it be take-home pay. The take-home pay is the monetary equivalent, the monetized value, Your Honor, of the salary grade. So for me, they're just the same. So I don't change my answer, Your Honor.
There's a difference between a salary grade and a take-home pay. Because before the effectivity of JR4, how much does a nurse 1 receive?
A salary grade 10, Your Honor, 11,000.
11,000. At the time of the effectivity of JR4, which fixed the salary grade to SG 11.
SG 10, Your Honor.
No. The JR4, AO 811, fixed the salary grade to
Yes, Your Honor.
SG 11, right?
Yes, Your Honor.
So how much would now be the entry level for nurses
Now, Your
under
Honor,
SG 11?
around 20.
18,000. 18,000 for step 1.
Yes, Your Honor.
So it means that there is now a difference of about 7,000. There's an increase in pay at the time of the effectivity of JR4.
Yes, Your Honor.
So,
But if
so
you-
it means that the take-home pay has even increased, but not the salary grade. So there is really a difference between a salary grade and a take-home pay.
Your Honor, when we speak of take-home pay, do we include the taxes and other deductions?
No, the
Or the
take-home pay,
monetary equivalent of the salary grade?
no, it's what the nurse has been receiving as take-home pay, regardless of the salary grade. Anyway, you can just discuss this in your memorandum.
Yes, Your Honor.
Okay, thank you very much.
Thank you, Your Honor.
Justice Del Castillo. After after the Justice Del Castillo, we will have Justice Leonen, and then Justice Caguioa, Justice Hardelesa, and Justice Joey Reyes.
Just a few questions, Counsel. You're saying that JR4 is not a law, but it has the force and effect of a law.
Yes, Your Honor.
And I heard you just a while ago that that since it has not been declared unconstitutional, it remains to be constitutional.
Yes, Your Honor, because laws are declared
No, we're talking now of because it's your position that JR4 is not a law.
Yes, Your
It
Honor.
has just the force and effect of a law.
Yes, Your Honor.
Now, what do you think was the purpose of Congress in passing this, whatever you call it?
The purpose was to modify the compensation and position classification
What
of
do you understand by that?
to modify the existing compensation and position classification of government employees, Your Honor, because the last modification was made through Republic Act 6758 of 1989, Your Honor.
And thereafter, there was RA 9173.
Yes, Your Honor.
That's why. And so, thereafter,
Joint resolution.
JR4 was,
Yes, Your Honor, in 2009.
was passed,
Yes, Your Honor.
empowering
The,
the executive department.
authorizing, yes, Your Honor. That's the term, authorizing, as compared to the 1989 law, which they used the term urging, Your Honor. That's why when you authorize, you delegate, but when you urge, you just urge. But there's no delegation of powers, Your Honor. But in this joint resolution, they authorized the President.
And with this authority, the executive department lowered the salary grade of Nurse 1 or
They
nurses
lowered it to
in
salary
entering the
grade.
government
Yes, Your Honor.
to what?
They lowered it to salary grade 11, pegging it or benchmarking the salary grade 11 of the Executive Order 811 to a repealed law dated 1989, which is RA 6758. RA 6758 has been explicitly repealed in 2002 by Nursing Act of RA 9173. However, when Joint Resolution 2009 was passed by Congress, the respondents or the executive branch of the government issued Executive Order 811 giving back the base pay of nurses to the repealed law of 1989, which is salary grade 10, and saying to us that, oh, you should be thankful because we even increased it to 11. So technically, they did not, respondents did not recognize the existence of a subsequent law that repealed a latter law, Your Honor.
You just mentioned that RA 4 gave the authority to the executive department to regulate or modify compensation.
Yes, Your Honor.
And now that the executive department has done so with this Executive Order 811, it lowered, as you were saying earlier,
Yes,
the
Your
salary
Honor.
grade of
11.
Nurse 1 to just salary grade 11.
Yes, Your Honor.
What's wrong with that? I mean, what did the executive department violate any provision of JR 4?
Your Honor, they violate other provision. Yes, they also violate the provision of House Resolution 4. And at the same time, they violated the provision of Republic Act 9173 of 2002, wherein which it is mandated that the entry level for nurses is 15.
Yes, you said that already.
Yes, Your Honor.
What I'm just trying to drive at is, you just stated that Congress, through JR 4, authorized, that's the term, the President to moderate, no, the compensation, to regulate the compensation of employees in government, particularly nurses. So now that the President has done so, what's there to prevent the President from saying that the salary grade of nurses should be just 11? And by the way, would you know what the reason why the executive department did so? By the way, what was the purpose of the executive department in lowering the salary grade to 11?
On the basis of the correspondences given by the petitioners before the filing of this instant petition, Your Honor, the Department of Budget explained that the implementation of salary grade 15 will strain the coffers of the government. That's one. Second, it will cause wage distortion if they will be implementing salary grade 15 for nurses.
And let me just interrupt you there.
Yes, Your Honor.
By wage distortion, what do you mean by that?
Their explanation was, if we will be giving salary grade 15 for nurses, and the salary, for example, of other health workers is salary grade 11, it will create wage distortion, Your Honor.
What they're saying is that if you give a salary grade 15 to nurse 1 and a salary grade of 14 to a medical doctor that's entering the government service, do you think that there's some wage distortion there?
Yes, Your Honor, on the basis of
That's
the qualification.
precisely why the executive department came out with this EO 811. So what's so?
That's the problem, Your Honor, because instead of pegging the entry level of nurses and other health workers in the government sector of the same qualification to salary grade 15 as entry level, they lowered it. They diminished the prevailing salary grade. What would have been equitable is that for the executive department or the DBM to also benchmark the entry level or the base level of other health workers of the same qualification and class to salary grade 15 as entry level, and not to bring it down, Your Honor, because that would violate the very essence of social justice, Your Honor, which is the state shall promote the right of labor to equal pay and equal work, decent pay, decent work, Your Honor. So if we will be pulling them down instead of placing them up, it will not be equitable at all, Your Honor.
And never mind if we don't have the money for it.
Well, it is not for us to say that. It is for the Congress to say that we don't have money to fund
They're
that.
saying so already.
But, Your Honor, the mere fact that RA 9173 passed Congress, meaning it passed through the House of Appropriations, there is a money for that, Your Honor. Congress will, the Committee on Appropriations will not let go of the bill if there is no funding for that, Your Honor. That is the procedure in the House.
Okay, thank you, Counsel.
Thank you, Your Honor.
Attorney Justice Leonen,
Good afternoon.
do you want some rest?
No, I'm okay, Your Honor.
You're grimacing.
No, Your Honor, I'm okay.
Maybe because it is my turn to ask the question.
Exactly, Your Honor.
Really? Okay. You're familiar with LEAH Primitiva SAMACO-PAQUIZ?
Yes, Your Honor.
Is she a nurse?
Yes, Your Honor.
And she's not filing the case as herself, but as a member of Partylist.
Yes, Your Honor.
So LEAH SAMACO-PAQUIZ is a nurse.
Yes, Your Honor.
Yes. And Public Services Labor Independent Confederation is also a...
It is a government union. It is an umbrella organization of government union in the public sector, Your
So
Honor.
you have here a member of the House,
Yes,
the party
Your Honor.
list, and you have a union, correct?
Yes, yes, Your Honor.
Do they stand to be directly benefited by any of this?
Yes, Your Honor.
Or is it the individual nurses that will stand to be directly benefited?
The individual
So the members of the member of the House, which is a party list, will not get salary grade 15, correct? It
No,
is
Your
the
Honor.
members.
It also infringes the member of the House to legislature honor because
Okay.
the executive
Let's
branch.
go to that. What has ang Nars party list done in the House of Representatives to correct Joint Resolution number 4 or Executive Order 811?
First, Your Honor,
Has it given a proposed resolution?
yes, Your Honor.
And this proposed resolution, where is it? What is the status?
During the 16th Congress, the proposed resolution was to was that it filed a House resolution investigating the implementation of Republic Act
Okay,
917.
what happened with that? There is no investigation yet.
It was concluded already, Your Honor.
Okay, and what was the result? What was the result of the conclusion of that investigation?
That the executive branch will really not implement salary grade 15 pursuant to RA 9173, Your Honor.
Okay, and what else did the party list do? There is a joint resolution containing a repealing clause, which you just read in your opening statement,
Yes,
correct?
sir.
And here you have, because you said there is no plain, speedy, adequate remedy, you have a party list leading as a petitioner, which is a member of the House of Representatives. By the way, how many party list members are there in the House?
As of the 16th Congress, there are 298, Your
Okay,
Honor.
and how many members?
Party list, Your Honor, I'm so
Yes,
sorry.
party
50,
list.
50.
50. And how many members of the House?
298, 20%.
And you have one party list here that is not getting what it wants from the House.
Yes. Again, Your
Because
Honor.
what you should have done would have been to correct the repealing clause in Joint Resolution number 4 to clarify that Republic Act 9713 is still effective, correct?
Yes, Your Honor.
That would have been the proper course, right?
We've done that,
Yeah.
Your
So,
Honor.
in other words, no, you've done that. Have you been able to get majority of the House and the Senate to overturn the interpretation of the executive branch? Here you have
We cannot do
298
that.
members of the House of Representatives, and what they should be doing is legislating. And to legislate would mean that if there is an incorrect interpretation of the executive, then you address it by clarifying the law under which there is some confusion, correct?
We've done that, Your Honor.
Have you clarified the law?
Yes, Your Honor.
Have you clarified the law? In other words, have you corrected the source of the confusion? Or, in other words, you did not win a majority in the House or in the Senate, correct? Are you saying the House members are callous to the plight of nurses? That you were unable to get them to clarify what should be the salary grade of nurses?
Your Honor, we were able to clarify through the filing of a House resolution to investigate the
Yes, but the
implementation.
House resolution is only a beginning, correct? In order to do that, because there is some confusion between Republic Act 9713 and Joint Resolution number 4, both of which were acts of Congress approved by the President, and what you should have done should have been act within your political sphere, which was to correct the source of the confusion, which was the repealing clause.
Your Honor, if I may, the confusion arises upon the issuance of the executive
Yes,
order,
the executive
Your Honor,
order
not the joint
811
resolution.
is based on Joint Resolution number 4,
Yes,
correct?
yes, Your Honor.
Okay. If we act on your complaint, your petition, therefore, each and every minority member of the House and the Senate that cannot correct a law will go to this court, and therefore we become a super body. Is that not correct?
Your Honor, we don't want to correct the law. We want the law to be implemented. That's why we go to this court.
Executive Order 811 is based on Joint Resolution Number 4.
Yes, Your Honor.
Joint Resolution Number 4 creates an ambiguity from the point of view of the executive with respect to Republic Act 9713, not from your point of view, but from the official point of view of the executive, correct?
Yes, Your Honor.
Yes, and this is a co-equal branch of government, correct?
Yes, Your Honor.
So there is an act of Congress, there is an act of the executive.
Yes.
And by the way, you just accepted that Joint Resolution Number 4 is not unconstitutional, correct? In response to the question of Justice
I did not
Bernabe.
admit, Your Honor. What I said was I did not raise the constitutionality of Joint Resolution Number 4.
So insofar as we are concerned today, because you have not raised it, therefore we presume that it is constitutional also from your perspective.
Yes, Your Honor.
Yes, so it is constitutional. Joint
Yes.
Resolution Number 4 has the force and effect of law. Republic Act 9713 is law according to you, also has the force and effect of law.
Yes.
The executive interpreting all of this has Executive Order 811, correct?
Correct, Your
Yes.
Honor.
To clarify from your point of view as a member of the House would have been to pass a joint resolution clarifying the repealing clause in Joint Resolution Number 4, correct? Because you see, if every issue where a minority of the members of the House or the member of the House does not proceed to its conclusion of amending a law or clarifying what the law is, they will go to this court, and what will happen? We become a third legislative chamber, correct?
Sort of, Your Honor.
Yes. And we do not want that to happen with this court, correct?
Yes, Your Honor.
So we dismiss your petition.
No, Your Honor.
Why not?
You rule on our petition,
Okay,
Your Honor.
next. Yes, we rule it by dismissing.
No, Your Honor.
Yes, okay. Section, you cannot just argue by asserting something. That's not an argument.
Exactly,
Okay,
Your Honor.
that's simply an assertion, correct?
Yes.
And we are asking you to argue.
Yes, Your Honor.
Is this your first
Yes, Your Honor.
appearance
Yes,
in the
it
Supreme
is.
Court? Yes. You do not just say, because I want it, right? You argue, give us the premise, and give us the logical, the sound logical conclusion, correct?
Correct, Your
Yes,
Honor.
and I just gave you an argument against your petition. Maybe you will cover that more in your petition, right?
Yeah,
Yes.
in memorandum, Your Honor.
You're not questioning the constitutionality of anything, correct?
We are questioning the constitutionality of Executive Order 811, Your Honor.
Because
Because it,
what does Executive Order 811 violate in terms of the Constitution?
Your Honor, Executive...
Probably what you should have done is question the constitutionality of the joint resolution. But you just said that you are not questioning it. Here now, you're questioning Executive Order 811.
Yes, Your Honor.
Okay, what text in the Constitution does Executive Order 811 violate?
For one, Your Honor, Section 5 of Article 9B,
Which is?
the Congress shall provide for the standardization of compensation of government.
How does it violate that? It provides for the standardization. You mean to say we have the power to look at the wisdom of how it's standardized, the provisions? Okay, cover that in your memoranda because I do not want to take too much time because I think there are many justices that will want to ask you questions. Section 26, Article 6. You have the Constitution with you. Probably better if you've memorized it, like the Solicitor General has memorized the Constitution. Section 26, second paragraph, number 2. No bill passed by either house shall become law. Correct?
Yes, Your Honor.
Yes. Where does it say in the Constitution that a law can only be called a Republic Act?
Again, Your Honor.
Where does it say in the Constitution that a law can only be called a Republic Act? You ask your assistant to look at the
Yes.
Constitution, do a find search, and when you do that, there is nothing in the Constitution that says that a law can only be called a Republic Act. As a matter of fact, it was once called an act, correct? Laws were labeled as acts, correct?
Yes, Your Honor.
Or laws were called Batasang Pambansa, correct?
Before, Your Honor, yes.
During the period of martial law, not the martial law of the present administration, but martial law under the Marcos Constitution, it was executive order, presidential decree,
Presidential
general
decree.
order, letter of instruction,
Yes,
etc., correct? Who gives the label? Who gives the label? Supreme Court, the President, or C, Congress? Multiple choice na lang tayo, parang bar. Okay? Not the 2020 bar. It will be easier. But first, A, the President gives the nomenclature, the Supreme Court, or is it Congress?
It's the Congress, Your Honor.
Yes, and Congress here called it joint resolution, right?
This one, yes, Your Honor.
Yes. So the joint resolution here is law.
No, Your Honor.
Why
it has
not?
the force and effect
Okay.
of law.
Was it enrolled?
No, Your Honor, it was not enrolled.
Really?
It was
Looking at-
consolidated. It was
Looking at
consolidated.
joint resolution, was it signed by the secretaries of the House and the Senate?
It was signed by the...
Secretaries of the House and the Senate, correct?
Yes, Your Honor.
Yes, and it was signed by the President, correct?
Yes, Your Honor.
If it is a resolution only stating the sense of the House or the Senate, does it need approval by the President?
If it's a concurrent or simple, no, Your Honor.
No, because that means that if the President still concurs to it, it's no longer the sense of the House or the
Exactly.
Senate, correct?
Exactly, Your Honor.
If it is given to the President after 3 separate readings of both the House and the Senate, then it's called a law, correct?
Yes, Your Honor.
So you accept that it's a law.
No, Your Honor. It was not even enrolled.
Again, you cannot argue by simply saying the conclusion. Okay? Here is the premise. It passed through 3 readings as you manifested in your in your opening statement, and it was given to the President, and as you say now, it was enrolled.
Yes, Your Honor.
And therefore, it doesn't make sense to look at all the records of the House and the Senate because of the enrolled bill theory, correct? That it passed through 3 readings is now certified by the Secretary of the House and the Senate, correct?
Correct, Your
Yes,
Honor.
and therefore it was signed by the President also and approved by the President. It passed through all the substantive requirements of the Constitution. It is law because it doesn't say that law is called Republic Act only. The
No.
only thing missing is you're saying it was not called a bill when it was being presented.
Among others, Your Honor, it has not also gone through the committee hearings before consultations with
Can we go
stakeholders, Your Honor.
beyond the enrollment of the bill? Can we investigate the Senate and the House as to what the procedures were? What you have to do first is to nullify the certifications of the Secretary of the House and the Secretary of the Senate. Correct?
Correct, Your Honor.
Yes, and that is not for the Supreme Court to do. Because you will have to provide evidence that there was fraud or collusion or corruption or misrepresentation that was done. Correct? Enrolled bill theory. Mabanag
Yes, Your
versus
Honor.
Lopez Vito, you remember
Yes,
that
Your
case?
Honor.
And the Supreme Court said, we cannot go beyond that because doing that would mean that we are a super body again over Congress, correct?
Correct, Your Honor.
Yes. You're familiar with the presumption of constitutionality, right?
Yes, Your Honor.
And part of it is also, the corollary is the doctrine of avoidance, correct?
Yes, Your Honor.
If there is a way that the co-equal branch of government like the Supreme Court can avoid ruling on the nullification of an act of a co-equal body, it will, correct?
Yes, Your Honor.
So what is wrong here is that they made the mistake of calling it a joint resolution, not a Republic Act.
Well, prior joint resolution
Perhaps
number
you can
4,
issue
Your
a
Honor,
writ
there
of
was
mandamus
also...
saying that it should no longer be labeled joint resolution, we call it Republic Act. Because just changing the nomenclature means that it's not unconstitutional because it passed through 3 readings of both houses. So the only problem here is the nomenclature, correct?
No, Your Honor, I think it was the intention of the legislature to name it as joint resolution because it was always, they are always, it's not just only joint
You don't get
resolution number.
me. You don't
They-
get the question. You shifted. Okay, my question was, if we replace joint resolution with Republic Act, is it unconstitutional?
Unconstitutional.
Yes. Is that entire thing unconstitutional? Joint resolution number 4, tanggalin natin yung joint resolution, lagay natin Republic Act.
With
In
the,
terms of the process, in terms of its content, is it unconstitutional?
having been a bill, Your Honor,
The way it is now, that it passed through 3 readings.
yes, it would be unconstitutional, Your Honor.
Because,
Because,
again, don't argue on the basis of the result. Follow my premise.
because the Constitution provides that
The
no
Constitution
bill shall
provides
become a law.
no bill, yes.
Yes, Your
If you
Honor.
only focus on the concept of bill, but you look at the substance of the provision, it says 3 readings.
Exactly, Your
By
Honor.
the way, was it
That's
passed,
the process, Your
was it
Honor.
passed in secret? Was it passed in secret?
It was hastily passed, Your Honor.
Oh my God, you're now accusing your branch of government to have duped the public in terms of Joint Resolution Number 4,
For the-
officially.
For the record, Your Honor, Joint Resolution Number 4 was approved in June 17 of 2009. Executive Order 811 was likewise signed on the same date, Your Honor.
And is that not efficiency?
No, Your Honor.
Why?
Because there was no publication. It was not published prior the prior executive
Are you
order was.
questioning now Joint Resolution Number 4? It's not in your pleadings.
No, Your Honor, it's just during our discussion.
So you are again claiming the validity of Joint Resolution Number 4. Cover that in your memorandum.
Yes, Your
How
Honor.
we apply the doctrine of avoidance and the concept of presumption of the constitutionality of the act of Congress. By the way, this is not only the act of the House, correct?
Correct, Your Honor.
This
Also
is
the
not
Senate.
only the act of the Senate, correct?
Yes, Your Honor.
Yes, it is also the act of the President,
President.
correct? And you are wanting us to declare what? As unconstitutional.
The Executive Order 811, Your Honor.
Again, on what basis? Again, what provision of the Constitution? I need to anchor a decision on the basis of a text of the Constitution. Because you did not target Joint Resolution Number 4, you targeted Executive Order 811.
Yes, Your Honor, but based on the prior discussions, joint resolution cannot repeal
You want us to
section.
declare Executive Order 811 as illegal.
No, only insofar as that provision pertaining to the salary grade 11 of nurses, Your Honor.
But your action is mandamus.
Yes, Your Honor.
Okay? And your action is mandamus. It means that there is a positive act that should be done by the executive branch.
Yes, Your Honor.
And we are compelling them to appropriate.
No, executive
Counsel,
branch cannot
When
appropriate
has this
to
Supreme
implement,
Court,
Your Honor.
when has this Supreme Court ever issued a writ of mandamus to the entire executive branch?
Your Honor, it's just under
Give me a case where this court has issued a writ of mandamus against the executive.
Yes, Your Honor.
Give me a case. Because you're asking for mandamus.
Yes, Your Honor.
You must have a precedent, correct? Anyway, in your memoranda, counsel. Okay. Lastly, counsel, you signed the pleading 6 compliance pending issuance of certificate. What does this mean?
I just gone through my MCLE and then the IBP is processing the issuance. However, Your Honor, my compliance is not yet expired. The 5th compliance, Your Honor.
Okay, just asking.
I just, in good faith, I just indicated it, Your Honor.
Yes, just asking. Thank you.
Yes, Your Honor.
May I be clarified before I go to the next interpellator? Are you the Congresswoman?
No, Your Honor, she's my mother.
Uh-huh. So you are the lawyer.
Yes, Your Honor.
Okay, thank may we now have Justice Kagiwa?
Thank you, Chief. Just a few questions, Counsel.
Yes, Your Honor.
Are you familiar with Republic Act 9524 or the 2009 GAA?
Not so much, Your Honor.
You know what the GAA means?
General Appropriations Act, Your Honor.
For the year 2009. Did you look at it?
No, Your Honor.
That's a Republic Act.
Exactly, Your Honor.
That's a law.
Yes, Your Honor.
correct? Can I ask you to look at the screen? That section, special provision number 1 of the Miscellaneous Personal Benefit Fund. It says in section 1, letter B, salary adjustment, the use of the funds for payment of other personal benefits, the amount authorized herein for payment of other personal benefits shall be used for letter B, salary adjustment and associated benefits and such other benefits as may be authorized by the law or by the President of the Philippines. Are you familiar with that provision?
Yes, Your Honor.
You are? Okay, do you know when this GAA was promulgated? This Republic Act, this law. Do you remember when it was promulgated?
2009, Your Honor, but not the exact.
March 12. It preceded EO 811.
EO 811 was approved, Your Honor, in June 17, 2009.
Since the GAA
So
or
this
the
was
Republic Act is
prior.
March, it is prior.
Yes, Your Honor.
Isn't that last paragraph statutory legal basis for the President to issue EO 811?
No, Your Honor, because this is an appropriations bill.
Which has the force and effect of law as
Yes,
it
Your
is
Honor.
law. And it
Yes,
says there that the President can.
Yes, Your Honor.
Therefore, the underlying legal basis for 811 could in fact be the
It
general
could, Your Honor.
It could.
It could.
So you agree with me that it could be.
It could, Your Honor, possibly.
Are you familiar with the GAA subsequent to the year 2009?
2010.
I'm talking about Republic Act 9970, Republic Act 10147, and Republic Act 10155, which are the GAAs for the years 2010, 2011, and 2012. Are you familiar with that?
Yes, Your Honor.
Okay. Can I ask the screen to show Republic Act 9970? Again, special provisions number 1C. It says, and I read for the record, requirement for the second tranche implementation of the salary increase authorized under Senate and House of Representatives Joint Resolution number 4, series of 2009. Do you confirm that that's what it says?
Yes, Your Honor.
That is a law
Yes, Your Honor.
that incorporates Joint Resolution number 4.
Yes, Your Honor, but it was not joint resolution number 4 that provides for the... Yes, Your Honor, I agree. Sorry.
It says requirement for the second tranche implementation of salary increases authorized under Joint Resolution number 4. Here, you, Counsel, you have a law in the name of the General Appropriations Act incorporating directly by reference Joint Resolution number 4.
Yes,
Do you
Your Honor.
agree?
Agree, Your Honor.
Therefore, the second tranche to be implemented is now by virtue of an actual law, assuming for the sake of argument that JR number 4 is not a law. Correct?
Yes, Your Honor.
So that is a law.
The joint resolution number 4.
GAA.
Yes, it is, Your Honor.
Okay.
It is
Can-
a Republic Act.
Can we go to Republic Act 10147? Again, special provision, number 1, letter C. Can you read? It says, requirement for the third tranche implementation of the salary increase authorized under Senate and House of Representatives Joint Resolution number 4. All right. Republic Act, GAA, promulgated in the year 2011. That is law, correct?
Correct, Your Honor.
And that provision explicitly refers to Joint Resolution number 4,
Yes, Your Honor.
adopts it by reference.
Yes, Your
Correct?
Honor. Correct.
Therefore, assuming for the sake of argument the Joint Resolution number 4 is not a law per your argument, the third tranche is by virtue of law, correct?
Correct, Your Honor.
Can we go to the Republic Act 10155? Again, I call your attention to number 3, letter B.1. Letter B, it says, use of funds for payment of other personal benefits, the amount appropriated herein for payment of other personal benefits shall be used for, letter B, salary increases authorized under Senate and House of Representatives Joint Resolution Number 4 as follows. B-1, full year requirement for the third tranche salary increase as implemented by EO number 40, and B2, requirement for the fourth tranche salary increase authorized under the foregoing joint resolution. My question is the same. Is that a law?
The GAA, Your Honor?
Yes.
Yes, Your Honor.
And does that provision of the GAA make specific reference to joint resolution number 4?
Yes, Your Honor.
And therefore, even assuming for the sake of argument, the joint resolution number 4 is not a law, the contents of JR number 4 was explicitly mentioned there and being implemented therein, correct?
Correct, Your Honor.
Is it true, as the Solicitor General has stated in its comment, that after the passage of JR number 4, the Senate and the House has proposed measures to upgrade the salary grade of government nurses from SG 11 to 15? Is
Yes.
it true? The Solicitor General mentions House Bill number 178, dated August 5, 2013, and Senate Bill number 2688, dated March 11, 2015.
Yes, Your Honor. There are legislative measures proposing for the salary of nurses from 10 to 11, Your Honor.
After JR 4.
I just don't know the exact date of filing, Your Honor, of the said bill.
According to the Solgen, HB number 178 was August 5, 2013. So that would
that
be
was
after.
after. Yes, Your Honor.
So Senate Bill number 2688, that will be March 11, 2015.
That was before.
2015?
After, Your Honor.
Okay.
Sorry.
What about House Bill number 151? Are you familiar with that?
The comprehensive nursing law, Your Honor.
No, it's introduced by Nars Partylist Representative LEAH.
Comprehensive
SAMACO.
nursing law, Your Honor.
Okay.
Yes, Your Honor.
When was that filed?
It was filed June 30, Your Honor, of 2013.
Also after JR number 4,
Yes, Your Honor.
correct?
Yes, yes, Your Honor.
Aren't these admissions that in fact JR number 4 is a law and it repealed the Republic Act? That's why you felt it necessary to file a separate law?
No, Your Honor. Actually, the House Bill 151 demands that the salary grade of nurses be salary grade 15, both in the public and the private sector, Your Honor.
So it's different?
Yes, Your Honor.
It expands.
It upheld the salary provision in RA 9173, Section 26, Your Honor. However, in 9173, what is only explicit is that salary grade 15 is only applicable for nurses in the government sector. In the House Bill 151 of 2013, what has been being asked, or in that provision, is that salary grade 15 be implemented both in the public, LGU, and its monetary equivalent insofar as private sector is concerned, Your Honor.
Okay, let me
Yes, Your Honor.
apologize for being unclear about my question. When
Yes,
did
Your
you
Honor.
file this petition?
This petition, instant petition, Your Honor?
Yes.
It was filed January 8, 2015, Your Honor.
And this proposed bill was filed when?
Again, Your Honor.
This proposed bill, HB 151.
Yes, Your Honor.
When did your mother file it?
June 30, 2013, Your Honor.
So 2 years prior to filing this case.
Yes, Your Honor.
So isn't that forum shopping? You are getting remedies both sides.
No, Your Honor, the bill is filed in Congress to repeal RA 9173, Your Honor. But the petition filed here is to compel the executive branch to implement the provision of Section 32 of RA 9173.
So your House bill has nothing to do with Joint Resolution number 4?
Yes, Your Honor.
It does.
It doesn't. Because Joint Resolution number 4 does not mention any salary grade for nurses, Your Honor. It was Executive Order 811, Your Honor.
Correct. But Joint
Yes, sir.
Resolution number 4 is the basis for Executive Order 811, correct?
Yes, Your Honor.
And there
among
is a
others.
specific explicit provision in Section 16 that the Republic Act has been repealed by JR number 4, correct?
No, Your Honor, it was not expressly said.
Can we go again? Can I ask the screen to go to JR number 4? There, it says, Section 16, Paragraph 16, Joint Resolution number 4, Amendment of Existing Laws.
Yes, Your Honor.
Provisions of all laws inconsistent with the provisions of Joint Resolution number 4, such as Republic Act number 9173. Isn't this an explicit repeal?
Of what provision of 9173, Your Honor?
Section 32.
But it does not mention any Section
Okay.
32, Your Honor.
The Solicitor General has mentioned in its comment that the congressional records indicate a debate precisely on Section 32, and that a vote thereon was in fact had, and the vote was for JR number 4 to continue as is and thereby not allow Section 32 of 9173 to continue.
Yes, Your Honor. Congressional records likewise states that they will be providing for that, meaning they will be providing for that corresponding salary grade for nurses because there is already a conflicting law if they will be changing the salary grade of
Okay.
nurses. But the intention was to change it, but they never really included it in the joint resolution, Your Honor.
But Joint Resolution number 4, as worded that way, effectively repealed Section 32 with the promise from the members who were debating that they will seek the increase of the salary grade, and that's probably why you have all this other legislation, proposed legislation coming after Joint Resolution number 4, correct?
No, Your Honor, it does not expressly repeal Section 32 of 9173, Your Honor. That is our position.
Okay, thank you. Nothing.
Thank you, Your Honor.
Justice Hardeleza.
Counsel, can you please, do you have your manifestation which you filed with this court last Friday, February 22? Do you have it with you now?
Yes, Your Honor.
I noticed that you materially changed the content of what you submitted last Friday and what you are arguing today, right?
Just a little, not material, Your Honor.
Well, I beg to disagree with you. For example, on page 2, I quote, "It is true that a joint resolution partakes the nature of a law." Do you see that?
Yes, Your Honor.
And on the last page of what you submitted last Friday, the penultimate paragraph before the final paragraph, I don't have to read it, but in effect you are saying there's really no conflict between 6758, RA 91.7, and even Joint Resolution number 4. You were trying to reconcile all of them, right?
Yes, Your Honor.
And then a while ago, you conceded that you did not raise the issue of constitutionality of JR number 4, right?
I raised it, Your Honor.
Show me where in your pleadings did you raise it. You just conceded a while ago to Justice Leonen, to Justice Bernabe, that you did not. Because in fact, counsel, you did not.
In the petition, Your Honor, it was not raised. What was raised in the petition was the constitutionality of EO 811.
That's right.
Yes,
Because
Your Honor.
what you raised in your petition is not the constitutionality of JR number 4, right?
Yes, Your Honor.
Therefore, what you raised was, to me, a question of statutory construction. Was it repealed? Was the Nursing Act repealed? In fact, you're saying you don't need to repeal. So to me, the issue you presented is an issue of statutory construction, not unconstitutionality. You remember the requirements for judicial review?
Yes, Your Honor.
Number 1.
There's an actual case or
Number 2.
Locus Standi, Your Honor.
Number 3.
That the resolution will benefit the agreement.
And do not forget that the issue of constitutionality must be raised,
Yes, Your Honor.
right? And that the issue of constitutionality must be the least.
Mota, yun,
Mota.
the case, Your Honor.
And I am suggesting that by not raising it now, midway, you are raising it, number one. And number two, you are suggesting that it is the least mota of this case. Now, let me go to your Friday submission. You, a while ago, I believe, and correct me if I did not hear you right, you seem to be suggesting that you tried to verify whether indeed JR number 4 was passed on 3 separate readings, right?
Yes, Your Honor.
And in fact, I think you said you tried to get certifications, but they were not made available to you, right?
Yes, Your Honor.
But that assertion is not contained in your submission as of Friday 2/18.
Yes, Your Honor.
2:18 in the afternoon.
Yes, Your Honor.
So when did you have an epiphany to make that assertion now? Remember, we had a long weekend, right?
Yes, Your Honor.
So you tried to look at certifications during the long weekend?
No, Your Honor. I just included it in my.
But if you had already sought the certifications, why? Because it's a very, very important assertion. You heard Justice Marvick. In effect, you're accusing two separate of a branch of government that they, whatever the word is, they made magic. So that's a very grave accusation. But if you stumbled on those facts, why did you not include it as of last Friday?
Your Honor, I revised it a little, and then I have copy here with me of the.
That is not the question, counsel. If that is very important because you're assailing you're assailing not only the validity but the faith and credit that a separate branch of government is saying by having an enrolled bill. It is a very grave accusation. So I am wondering, why is it that if it is so important, you did not include it in your Friday submission and you're doing it only now?
Yes, Your Honor.
So what's the explanation?
Maybe I just missed it, Your Honor.
So when did you have an epiphany that it is important? Only how many minutes ago?
No, Your Honor. During when I revised it, Your Honor.
When you were rewriting this during the weekend?
Yes, Your Honor.
And exactly what was the circumstances? Why did you have an epiphany all of a sudden that it was important?
It was the advisory was about the procedure of how a joint resolution becomes a law, Your Honor.
Thank you. Now, a while ago, you agreed to certain questions about the U.S. Constitution, right?
Yes, Your Honor.
It is Article 1, Section 7, I believe, of the U.S. Constitution. Do you have it with you?
The U.S. Constitution, no, Your
Yes,
Honor.
no. In fact, again, in your petition and in your reply, you did not refer to the U.S. Constitution, right?
Yes, Your Honor.
In fact, it is for the first time today that you have heard that an argument could be made about what the U.S. Constitution says and what we followed or what we copied or what we did not copy, right?
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Justice Joey Reyes.
Just a few simple questions. You seem to be having difficulty, Madam. So we will end probably the interpellation at this point, but just a few simple questions. Madam Counsel, are you aware, or how many registered nurses are there in the Philippines now? Nurses who passed the board exam and registered with the PRC, or the Professional Regulations Commission. I'm
As-
sure there are officials here of.
As of 2016 records of the PRC, Your Honor, there are 800,000 nurses, Your Honor.
All right, 800,000 nurses registered.
Yes, Your Honor, but that was not updated as to whether they are dead or abroad.
Right, and how many nurses are in the Philippines?
Sadly, Your Honor, we don't have really status or database for that.
All right. Now, this problem about the change in salary grade from 10 to 11 started in 2009 when Executive Order 811 was signed by then President
Gloria.
Arroyo.
Yes, Your Honor.
Now, there are how many? There are, let's say that there are only 700,000 nurses.
Yes, Your Honor.
And they're all members of an association. Are you aware of the existence of the PNA or the Philippine Nurses Association?
Yes, Your Honor. Actually, they're present right now.
They're present right now. Now, what is the stand of the Philippine Nurses Association insofar as this issue that you brought to the court?
They are one with the petitioners, Your Honor, to implement salary grade 15 as entry-level pay for government nurses, Your Honor.
But the petition was filed by the party list.
Yes, Your Honor.
And do you have a written statement or manifestation from the PNA authorizing the petitioner here right now, party list, authorizing ang Nars party list to initiate this petition?
None, Your Honor, because the initiative of the Nars party list culminated from the legislative prerogative of one of the petitioners, Your Honor. As compared to PNA, they are private organizations of nurses, the accredited professional organization, Your Honor.
So this would...
Yes,
all
Your
right,
Honor,
go
sorry.
ahead. This
So
would appear to be a
certification
big
from
group.
them is...
This is indeed a big group, meaning the PNA is such a big group, right?
It is, Your Honor, considering that they are the accredited professional organization duly recognized by the Philippine Regulatory Commission, Your Honor. So almost all nurses registered to them, Your Honor, just like IBP.
So you could easily call all of them together and you can voice your concern to the president, maybe, easily. Do you know that the president has a, soft spot in his heart for nurses, especially
because,
those who are
yes.
abroad?
Yes, I know,
So
Your Honor.
why didn't you gather the PNA instead of going to the Supreme Court?
Your Honor, this was filed prior our present president, Your Honor. But efforts were made to communicate with Ms. Hanilet
Who is Hanilet?
the common law wife of the president, to help us with the cause of the nurses.
Oh,
Your
has
Honor.
there been any progress?
Your Honor?
Has there been any progress?
Yes, Your Honor, insofar as oppression and exploitation in the labor rights are concerned, Your Honor.
All right. Now, but our concern here is the effect of Executive Order 811.
Yes, Your Honor.
Now, why didn't you pass a manifesto and submit it to the President of the Philippines, considering that Executive Order 11 was issued by the President then? So I'm sure the President now can easily issue as well an executive order, probably rectifying or granting your request.
Your Honor, for the record, just last February 2016, we wrote a letter to the President urging him to implement salary grade 15 for nurses, especially especially those nurses under the nurse deployment program, considering that these nurses are contractuals and they are the ones being deployed in the GIDA areas, Your Honor. But up to now, no positive response yet, Your Honor.
Perhaps you are lacking in initiatives.
Well, we'll try to coordinate with other nurses group to make the efforts more appealing for the President, Your Honor. We'll do that.
Why didn't you talk to the Solicitor General? He is the lawyer for the Republic of the Philippines, and he can easily help you.
We'll ask him later, Your Honor.
And then withdraw the petition, right?
No, Your Honor.
This is the fastest way to solve your problem, you know.
No, Your Honor, because there is really a legal issue that hampers the implementation of salary grade 15 that has to be solved
But,
long before 2009, Your Honor.
but you know, I can see that you're having a problem arguing with us. We wanted you to give reasons for our answers. But you know, there comes a time when you cannot find any reason, no, for your arguments. When science ends, faith begins.
I agree, Your Honor.
All right, so I think you have to make some follow-ups and work. Probably instead of pursuing the case here, you can resort to appeals to the office of the President. Can you do that?
We've done that already, Your Honor, but to no avail.
No, but probably you are lacking in
We will
initiative.
try again, Your Honor, but it is our position that this case be resolved by the courts, Your Honor.
Yeah,
by
but
the
what took you so
Honorable
long
Court.
to bring this matter to the court? From 2011, now you filed it in 2015.
Yes, Your Honor. Ang Nars Partylist was seated in Congress in 2013, and then when during those times, it first filed the House resolution to investigate. It communicated with the Department of Budget, communicated with the Department of Health, in order for them to implement salary grade 15, but to no avail. Until such time that the only recourse for the petitioners was to file this instant petition, Your Honor.
All right, thank you, Counsel.
Thank you, Your Honor.
Yes. Before Justice Hernando interpolates, may I return the interpolation to Justice Ardelesa for one question?
Just one question, Counsel.
Yes, Your Honor.
And I apologize, I forgot to ask this. In your presentation a while ago, you quoted a very, very interesting exchange between, in the House, I believe, between Representative Rodriguez and Representative Uwa. Yes,
Yes, Your
and what struck me was the quote from Representative Rodriguez, and he says, and I quote, and I think you quoted this, correct me if I'm wrong, joint resolutions are, according to U.S. jurisprudence, resolutions in Congress for small matters that are taken up by Congress. End of quote.
Yes, Your Honor.
Yes, you quote. Now, again, I'm wondering, because this quote about this exchange between these two gentlemen of the House is not contained in your Friday submission
I
to
will
us.
file it, Your Honor.
I'm sorry, no, that's not the question. I'm interested to know is, again, just like, when did it occur to you that during the long weekend, the Congress was closed, so you must have had already this exchange, but you did not seem important to you when you submitted it Friday. So what happened?
No, Your Honor, I researched that last 2 weeks ago, but when I finalized it during the weekend, I found it needed to include it in my presentation today, Your Honor.
Thank you very much.
Thank you, Your Honor.
Justice Hernando?
Thank you, Mr. Chief Justice. Counsel, you said you're not questioning, really, JR number 4, but EO 811, on the ground that EO came up with provisions that is not in consonance with proper delegation of legislative powers. No?
Yes, Your Honor.
Okay. Can you read the title of JR number 4 itself, please?
Joint resolution authorizing the President of the Philippines to modify the compensation and position classification system of civilian personnel and the base pay
Stop
schedule.
right there. Civilian personnel, that would include
Yes, Your
nurses,
Honor.
no? And also doctors and other professionals in government. Would you know the salary grade of doctors at the time of the enactment of the law giving that SG 15 raise to or upgrade to nurses?
No, Your Honor.
It was SG 14.
14.
No? SG 14, meaning to say that the upgrade of the salary grade of nurses from 10 to 15 would place the nurses at a higher SG than doctors.
Yes, Your Honor.
And because of that, EO 811 was signed by the President pursuant to JR number 4,
Yes, Your
which
Honor.
was to equalize the level field for salary grades of professionals in government, such as nurses and doctors. And the President could see very well that an SG 15 for nurses would be inequitable to doctors, who would only be receiving at that point a salary grade of 14. Very clear, no? And that was the basis for EO 811. It is, in fact, consistent with the constitutional mandate for a classification of salaries for government employees that's equal to all. Would you agree?
Yes, Your Honor.
So why are you questioning EO 811 then?
Because during, Your Honor, during the House investigation on the implementation of 9173, the intention was to benchmark the salary grade of health workers to salary grade 15 pursuant to 9173, so as to prevent wage distortion insofar as to other health workers are concerned.
Precisely, no?
Yes, Your Honor.
If you would look at EO 811, Section 6, a nurse one the SG for a nurse one was upgraded from SG 10 to 11. And then
Yes,
just
Your Honor.
below her, a medical officer one, 14 to 16.
Yes, Your Honor.
So EO 811 precisely tweaked prior statutes on the classification of salary grades of professionals in government, precisely so that this would be in consonance with the Constitution.
Yes, Your Honor, but it violates a valid and existing law, Your Honor.
But not the Constitution, because that's the test against which it should stand, counsel.
So they should have at least filed a law to repeal RA 9173, Your Honor.
Well, since precisely you have not questioned JR number 4, it has repealed the prior law giving that upgrade to nurses. As you said, while it's not a law, it has the force and effect of a law. And one effect of a law is repeal, isn't it?
Yes, Your Honor, but a joint resolution cannot repeal RA 9173 impliedly, Your Honor.
So it must be expressed?
Exactly, Your Honor.
All right. The Senate version that gave rise to Joint Resolution number 4, and up to the point where it was signed into law by the President, you mentioned June 17, 2009, no?
June 17, Your Honor, yes.
It was done all in a day's work, Counsel?
Yes, Your Honor.
All in a day's work?
Yes,
From
as
the
per...
sponsorship in the Senate all the way up to the signing by the President
Yes, Your Honor.
on June 17, 2009?
Yes, Your Honor.
I'm not so sure about that because I would like to enlighten you, counsel. No? If you cared to look into the legislative history of JR number 4, it was on May 26, 2009, it was prepared and submitted jointly by the Committee on Finance and Civil Service and Government Reorganization. And a number of senators, in fact, put that in the calendar of the Senate on that date. The principal sponsor was the late Senator Edgardo J. Angara. It was sponsored by the late senator, and later on the very same day, all senators were made co-authors on May 26. On that same day, also, there were interpellations, no? Done by Senators Pimentel and Mar Rojas. And the following day, it was certified by the President for its immediate enactment. So the President saw the need for it to be enacted at the soonest possible time, precisely because of the grave consequences that the law may entail. And on that same day, more senators conducted interpellations. These were Mar Rojas, Alan Peter Cayetano, then Senator Benigno S. Aquino III, Pia Cayetano, and then Aquilino Pimentel Jr. Interpellations were then closed on that same day, and there was a second reading, Counsel, of that Senate version, and a third reading, although on the same day, okay? And there was then voting, with 10 senators voting against 0 or 1, with abstention none. Senate then requested the House for a conference to settle conflicting issues. And there was such a conference on June 2, 2009. There was a conference committee report, in fact. Our legislators spent time and effort on JR number 4, Counsel, unlike the scene that you would picture before us. And then on June 3, this conference committee report was approved by both the Senate and the House. 12 days passed before there was an enrollment, Counsel, of the consolidated version, not just one version of the Senate or of the House, but of the consolidated version. And on June 17, after the enrollment, this consolidated version was then signed into law by the President of the Republic. It was not all in a day's work, Counsel, as you would picture it to be. It, in fact, went through substantially the process for passage of laws under our Constitution, don't you think?
Yes, Your Honor. Aside from that, the 3 readings was not done in 3 separate days, Your Honor.
Is that a substantial requirement?
Yes, Your Honor, in passing a law.
I mean to say, is there a need for Congress to strictly pass bills in 3 separate readings under the
Yes, Your
Constitution?
Honor, as laid down in the procedures of the Constitution, Your Honor.
So it cannot be one reading on day one and then second and third readings on the second day.
As long as it's 3 separate days, Your Honor.
But then, going back to the legislative history of JR number 4, it in fact went through readings, 3 in fact, and there was enrollment.
Yes, Your Honor.
We are now bound. This court is now bound by the enrolled doctrine theory, enrolled bill doctrine, I mean to say.
Not no, Your Honor.
Well, anyway, the gist of my question really is, EO 811 was signed into law by the President, consistent with the constitutional mandate that salaries of government employees must be equal in all respects, no?
Equitable, Your Honor.
Equitable.
Yes, Your Honor.
Precisely. And at the time that our hardworking nurses were given an SG-15 classification, there was, however, a problem with regard to the salary level of other professionals in government like doctors. At the time, doctors were receiving a salary that was commensurate to the pay scale of an SG-14 item. So if we were to implement that law giving nurses an SG-15 pay scale, then that would be inequitable to our doctors who are just as hardworking.
No, Your Honor. What will be equitable is for the DBM and the CSC to reclassify the position classification of other health workers such as doctor so as to increase their salary grade and not to pull them down, Your Honor. That would be the basis because the law has already set the standard for the entry-level pay for nurses, Your Honor.
No, because at the time that RA 6713 was passed giving nurses SG-15, doctors had their own pay scale under their own special law, and they were receiving SG-14. And 811 corrected that, isn't it?
811 modified that in such a sense, Your Honor, that in such a way, Your Honor, that
modified it
there's a
to make it more
diminution of salary,
equitable.
Your Honor, insofar as nurses are concerned.
But what about the other professionals in government council like our doctors?
That's why, Your Honor, the equitable solutions would have been to peg the entry level of other health workers to salary grade 15, depending on classification, qualification, skills, and capabilities, Your Honor.
Which is what 811 precisely did, don't you think?
No, what 811 did is that 811 revived the repealed law of 1989, which is RA 6758, wherein which it provides that the salary grade for nurses is salary grade 10. Instead of reckoning to the point of 2002 or RA 9173, the law that repealed RA 6758 or the 1989 salary standardization law, Your Honor, EO 811 used the repealed law, bringing it back to life, saying that the salary grade of nurses is salary grade 10, and now we're giving you a favor, and we will be increasing it to salary grade 11. When in fact, the salaries of nurses has been increased as early as 2002, Your Honor, to salary grade 15.
But precisely, 811 was signed into law so that the nurses compared to the other health workers like doctors would receive a pay scale that's equitable and commensurate to their qualifications and competence. Because obviously you cannot have, with all due regard to our hardworking nurses, they cannot be made to be entitled to receive a higher pay scale than doctors, no? Because of the educational costs that would go into medical education or education in medicine.
Your Honor, but
So it was meant to correct an inequity in the pay scale of the different health workers in government.
Your Honor, but the implementation of a law cannot be left to the determination of the implementing agency of the government, Your Honor. Since the law provides that the salary grade of nurses shall be salary grade 15, for the record, Your Honor, since the enactment of the said law in 2002, it was never implemented until such time in 2009 when joint resolution was enacted, Your Honor.
Yes, but 811 was signed into law by the President precisely because JR number 4 had repealed 6758.
Your Honor, but regardless of that point, still there is still no joint resolution number 4, but the executive branch refused a valid and existing law that was enacted in 2002 mandating that the salary grade of nurses shall be salary grade 15, Your Honor.
Anyway, thank you, Counsel.
Thank you, Your Honor.
Justice Peralta?
Just last question, but your answer, you can place your answer in your memorandum.
Yes, Your Honor.
Is there really a difference between a journal, a joint resolution and a bill?
Yes,
You don't need to give your answer now. You put that in your memorandum.
Yes, Your Honor.
Justice Gesmundo?
Yes, a few questions. Joint resolution number 4, is it your premise that this is not a law?
It has the force of effect of a law because it is dependent on Republic Act 6758, Your Honor.
How do we call this if this is not a law?
It's a joint resolution, Your Honor.
Did joint resolution number 4 created certain rights?
Yes, Your Honor.
Did it create certain obligations?
Yes, Your Honor.
And that's precisely the purpose of a law, right?
That's why it has the force and effect of a law.
Now, the joint resolution number 4 has an explicit provision on repealing clause. Section 16, I suppose you...
Yes, Your Honor.
Paragraph number 16 is very clear. It repealed 9173. And technically, it repealed Section 35, which you have been relying on.
32, Your Honor.
32.
No, Your Honor. It does not specifically mandates what specific provision in 9173. 9173, other than salary, contains also other provisions like the benefits and emoluments of nurses, Your Honor.
Can you read that number 16? It says there, issuances or parts thereof that are inconsistent. Don't you think that Section 32 is inconsistent with the joint resolution?
No, Your Honor, because there was no mention in the joint resolution in regards with the salary grade of nurses, Your Honor.
Yeah, but 9173, Section 32 is the one that you rely on. And don't you think that is inconsistent, that salary grade 15?
No, Your Honor, because joint resolution number 4 explicitly provides that the existing salary rates of the government employee shall be that which is effective as of that time.
What about executive number 811? How would you treat this?
811, Your Honor?
Yeah, EO 811. How do you treat it? What is it in relation to joint resolution number 4?
It's an executive order, Your Honor.
Is it not in the nature of an IRR?
Yeah, it is, Your Honor.
Okay, and therefore, if it's an IRR, there should be legislative issuance upon which you can rely for implementation.
Yes, Your Honor.
So, don't you think that 811 meets the parameters, the standards provided for in joint resolution number 4? What constitute a valid delegation?
It's just not joint resolution number 4, Your Honor, but also joint resolution number 1 and Republic Act 6758, Your Honor.
811 provides for the parameters to implement the standardization.
Yes,
so
Your Honor.
There should be no distortion. Is that correct?
No distortion, Your Honor.
Yes, and salary of other medical health employees of the government.
To standardize, Your Honor,
Yeah, but do you think it should the responsibility of Congress to provide all the details?
Yes, Your Honor, because the Constitution provides that it is the duty of the legislature to standardize the compensation of government employees, Your Honor.
Correct, but the point is in the implementation of standardization is the responsibility of the chief executive.
Exactly, Your Honor, but provided it complies with the sufficiency and
And the
completeness
reason
standard.
for delegating that power to the executive is why? What? Why is it delegated to the executive?
The implementation, Your Honor.
Yes, why? Why is
But
it
not the determination
the
of
general
the...
rule is that in the matters of implementation of legislation, it is delegated to the executive precisely it's to execute the law.
Exactly,
Why?
Your Honor.
Why is it delegated to the executive?
Because it is the duty of the executive to implement laws, Your Honor.
Yeah, but the point is Congress cannot be in a position to provide every details and put it in legislation. Is that not correct?
Yes, Your Honor.
And the executive is in a better position to determine the salary grade for each category of workers in government, being equipped with all the details and knowledge.
It is not to determine, Your Honor, but to implement what is the law mandates.
But still, there is a doctrine that, this the power can be delegated to the executive.
Yes, Your Honor, provided that it does not encroach on the powers of the legislative at the same time, Your Honor.
What in Executive 811 encroaches on the power of Congress to legislate?
For example, the Executive 811 encroached when it provided for the salary grade 10, from salary grade 10 to 11 of nurses, Your Honor.
Take a look at that item, last paragraph of number 16 of Joint Resolution number 4. Last paragraph. For the record. Number 16 of the Joint Resolution number 4, second paragraph.
To read, Your Honor.
Yes, please.
All provisions of laws, executive orders, corporate charters, implementing rules and regulations, prescribing salary grade for government officials and employees, other than those in Section 8 of Republic Act 6758 are hereby repealed.
So how do you look at that provision? Is it not a repealing clause?
No, Your Honor, because if you will correlate it to the non-diminution clause of the same joint resolution, it states that non-diminution in the basic salaries of incumbent employees. In no case shall there be any diminution in the basic salaries of incumbent employees upon the implementation of this joint resolution.
Was Section 32 implemented at the time?
Yet, what do you mean implemented, Your Honor?
Did they get the salary grade 15
As of 2009, Your Honor?
at the time?
No, Your Honor, it was never given.
So there was no diminution because you have not received it.
But it is the legal right and entitlement of nurses for them to receive it, Your Honor. That's why.
If the law was implemented, but the law was never implemented, so they never received the salary under salary grade 15.
Yes, Your Honor.
So there is no diminution.
But there is a denial of right, Your Honor.
No, you're arguing from the point of view of diminution of salary. But at that point in time, that section granting salary 15 as entry level was never implemented.
There is no vested right, Your Honor, but there is a legal and demandable right on the part of the nurses to receive the same.
There is
Your
no
Honor.
vested right yet, because diminution, when you talk of labor laws, is that you have actually received it. Even under the labor code. If you have received it and then it's withdrawn, there will be diminution. So that since you have not received it, there is no diminution. In other words, that salary grade entry level of 15 for nurses is just there, but it was never implemented.
Yes, Your Honor.
No government nurse received that salary grade 15. And therefore, there was no diminution because you have not received it. Is that correct?
Yeah, no vested right yet, Your Honor.
That's all. Thank you very much.
Thank you, Your Honor.
All right, the last interpellation will be done by Justice Andres Reyes.
Thank you, Chief. Before you filed the petition, you were making a research on the salary grades of the government employees.
Yes, Your Honor.
And recently, they announced that the police military were given increases in their pay. Actually, they say it's double the salary. Is this correct?
Recently, Your Honor?
Yes?
Yes, Your Honor. There was a joint resolution number 1 that was passed by Congress.
So what happened to the salary of the soldiers or the police? Were they doubled or were they increased by a percentage? Do you know?
Not specifically, Your Honor.
So do you know if they were increased by means of a salary grade adjustment or by a increase in the salary itself? You don't know also?
Your Honor, I have here the joint resolution number 1, authorizing the increase in base pay of military and uniformed personnel in the government. The increase was made pursuant to monetary equivalent on a monthly basis base pay, Your Honor.
So this is per GAA?
Via joint resolution, Your Honor. Joint resolution.
Not by GAA?
No, Your Honor. The GAA maybe funded it, Your Honor. But the basis for the General Appropriations Act is the joint resolution to fund or appropriate budget for the salary of the military personnel, Your Honor.
I'm just curious, are the pay of military nurses included in that salary increase? Military nurses, are they included in that salary increase?
Military and uniformed personnel in the government.
So it would assume that the military nurses enjoyed an increase in their salary. You don't know? You don't know?
No.
All right. Thank you so much.
Thank you, Your Honor.
Okay, thank you, Counsel. You will finally get your rest.
Thank you very much, Your Honor.
Just a while. Last question.
Yes, Your Honor.
Just a point of clarification. In the interpellations of Justice Hernando, speaking about the legislative history of JR number 4, you stressed that the Senate bill and the House bill were read 3 times but not on 3 separate days, correct?
Yes, Your Honor.
That's what you were stressing.
Yes, Your Honor.
And yet, that requirement of reading it on 3 separate days does not arise if the bill is certified by the President as urgent, correct?
Correct, Your Honor.
Were these bills certified as urgent?
Yes, Your Honor.
So, as far as the requirement of the Constitution for reading on 3 separate days, that is a non-issue, correct?
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Okay, may we thank you for
Thank you, Your
your
Honor.
time, Counsel. May we now require the Solicitor General to go to his presentation.
Before I start, Your Honor, for the sake of candor, may I be allowed to truncate certain paragraphs or sentences in my opening statement for time constraints, Your Honor.
Yes, you may.
Thank you, Your Honor. May it please the Honorable Court. In 2002, Republic Act number 9173 was enacted, granting our nurses and the government a minimum base pay of salary grade 15. But this piece of social legislation created conflicting salary grades and caused a great deal of disparity and inequity in the whole government structure, position classification, and compensation system. Indeed, Congress deemed it wise to pass Joint Resolution number 4 in 2009 to address this concern. JR number 4 specifically repealed Section 32 of RA 9173. Implementing the joint resolution, Executive Order number 811 reassigned the salary grade for the entry level of position of Nurse 1 from SG 10 to 11. Consequently, when petitioners filed the present case in 2015, asking this Honorable Court to uphold Section 32 of RA 9173, they were already praying at the wrong altar. The issue has become moot and academic as a consequence of the passage of Joint Resolution Number 4, Series of 2009, expressly repealing Section 32 of RA 9173. Absent a new legislative measure, there is no basis to grant entry-level government nurses salary grade 15. Therefore, the government cannot be compelled by way of mandamus to grant a salary grade 4. Number one, the petitioners lack legal standing to question the validity of EO 811. It has been settled that Locus Standi is the personal and substantial interest in a case whereby a person will incur direct injury due to the governmental act assailed, material and not merely incidental, present and not mere expectancy. To establish Locus Standi, the following must concur. Number one, the party personally suffered some actual or threatened injury because of the alleged illegal conduct of the government. Number two, the injury is fairly traceable to the challenged action. And number three, the injury is likely to be redressed by the remedy sought. In this case, Your Honors, petitioners have not identified their personal stake in the outcome of the controversy. They failed to establish how they would be directly affected by the implementation of EO 811. At most, they are parties actively involved in the social concerns of nurses. Petitioner former Representative LEAH PRIMITIVA PAQUIZ also has no legal standing in the present action since she is neither currently employed in government as a nurse, nor is she an incumbent legislator representing the nurses. Even in her incumbency as a legislator at the time this petition was filed in 2015, there was no sufficient allegation that her prerogative to legislate was infringed. Number two, the petitioners violated the doctrine of hierarchy of courts. The jurisdiction of the Honorable Court over the writs of certiorari and mandamus is not exclusive, but concurrent with the regional trial courts and the Court of Appeals. However, such concurrent in jurisdiction does not give petitioners unbridled freedom of choice to court forum. Here, petitioners failed to demonstrate that neither the RTC nor the Court of Appeals are capable of granting them the remedy they wish to obtain, assuming ex gratia argumenti that they are entitled to it. In view of these procedural infirmities, the instant petition should be dismissed. Number three, the repeal of Section 32 of RA 9173 through Joint Resolution Number 4, Series of 2009 by Congress constitutes a political question beyond the pale of judicial review. A political question is one which, under the Constitution, is to be decided by the people in their sovereign capacity, or in regard to which full discretionary authority has been delegated to the legislative or executive branch of government. The intricacies of lawmaking process are inherent to Congress alone. The passage of laws, except the people's direct power of initiative and referendum, rests solely with Congress. The plenary nature of this power, coupled with Congress's prerogative to determine its own rules, prohibits the judicial review of laws of whatever form, as long as the internal rules of Congress or each house thereof and the standards of the Constitution are complied with. Questions as to what internal rules are used in crafting congressional actions and whether the same are followed in the legislative mill are political ones outside of judicial review, even with the so-called expanded jurisdiction of the Supreme Court. Regardless of the appellation used, whether Congress calls a legislative measure a bill or joint resolution, It is not the business of the courts of law to impose their judgment on what has been invariably laid out in the Constitution as the prerogative of Congress alone. Joint Resolution Number 4 effectively repealed Section 32 of RA 9173. The legislative intent to treat a joint resolution of both houses of Congress as a law when manifest therein, notwithstanding its nomenclature, should be controlling. Item 16 of Joint Resolution 4 expressly amended all existing laws that are inconsistent with its provisions, including RA 9173 or the Philippine Nursing Act of 2002. Moreover, all provisions of laws and the like prescribing salary grades for government officials and employees, except constitutional officials, have been repealed by the same Item 16. Under Section 32 of RA 9173, the minimum base pay of nurses working in public health institutions shall not be lower than salary grade 15, quote, prescribed under RA number 6758, unquote. However, Section 9 of RA 6758 assigns salary grade 10 to nurse 1 and not salary grade 15, as stated in Section 32. Hence, Congress deemed it necessary to correct this through Joint Resolution Number 4 by repealing Section 32 of RA 9173. In the Philippine legislative milieu, as confirmed by both the Senate and House of Representatives, there is no real difference between a bill and a joint resolution. Both are laws. In fact, Your Honors, I have with me the position paper of both houses, and they both agree that a joint resolution is considered a law. Before a joint resolution is passed, it has to undergo the same process a bill undergoes. Unlike the other forms of resolutions issued by Congress, a joint resolution passes through greater safeguards and delays calculated to ensure the expression of a sober judgment. Under the rules of both the Senate and House of Representatives, a joint resolution like a bill is required to be filed, to undergo 3 separate readings, to be approved by both houses, signed by the presiding officer of each house, and enrolled for signature of the President. A joint resolution is also presented to the President for approval. Thus, a joint resolution upon approval of the President is law. Here, the enactment of JR 4 followed the procedure for enactment of a bill into law. Accordingly, JR 4, being a law, effectively repealed Section 32 of RA 9173. Number 4, Executive Order 811 validly fixed the salary grade 11 as the entry-level grade of government nurses. Joint Resolution Number 4 validly delegated the administration of the compensation and position classification system to the President through the DBM. Section 1, Article 7 of the Constitution states in no uncertain terms, and I quote, "The executive power is vested in the President of the Philippines," unquote. With this great power comes the great responsibility vested in the President under Section 17 of the same articles, that, and I quote, "He shall ensure that the laws be faithfully executed." Indeed, it is the duty of the President to enforce the laws of the land. Contrary to petitioners' claims of grave abuse of discretion in the issuance of EO 811, Joint Resolution Number 4 recognizes these constitutional powers of the President and called for him to exercise nothing more than what our Constitution provides. The attention of this Honorable Court is directed to RA 6758, the Compensation and Position Classification Act of 1989. Congress intended this law to reflect a dynamic civil service, responsive to the changing needs and circumstances of the Filipino civil servant. Thus, in Section 14, it empowered the President through DBM to administer the compensation and position classification system in the government service and revise it as necessary. It was in this light that JR number 1 was passed by Congress in 1994, urging the President to revise the existing compensation and classification system for civilian personnel and the base pay of military and uniformed personnel. Item 13 authorizes DBM to periodically review and update the compensation and position classification with the governing executive order to be issued by the President. Joint Resolution number 1 was approved by then President Fidel V. Ramos, which later on led to the promulgation of EO 164, series of 1994, adopting as intended all along by Congress in Section 14 of RA 6758, and item 13 of Joint Resolution number 1, a revised compensation and position classification in the government service. On June 17, 2009, JR 4 was approved by then Gloria Macapagal Arroyo. Joint Resolution number 4, more commonly known as Salary Standardization Law 3, authorized the President, like what Joint Resolution number 1 did, to modify the compensation and classification for civilian personnel. JR 4 validly delegated to the President the power to modify the compensation and position classification system because it passed both the completeness and the sufficient standard tests. It is complete because, as stated in its whereas clause, the policies to be implemented are to make the present compensation and position classification system more effective and to reform the present system and base pay schedule considering the distortion brought about by inequitable salaries. Moreover, item number 16 expressly repeals all provision of laws prescribing salary grades for government officials and employees other than constitutional officers. It has sufficient standards because item 1, the governing principles of Joint Resolution number 4, sets forth adequate guidelines or limitations in the law to map out the President's authority. Considering that there is a valid delegation of authority to the President, then President Gloria Macapagal Arroyo issued EO 811, prescribing the first tranche of the modified salary schedule and increasing, among others, the salary grade of Nurse 1 position from 10 to 11. Neither Executive Order 811 nor Joint Resolution number 4 caused a diminution of salaries of government nurses. Petitioners, in contending that the assailed EO 811 caused a diminution of salaries of government nurses, anchored their argument on Section 32 of RA 9173, which pegged the minimum salary grade of government nurses at 15. However, item 16 of JR 4 states that all provisions of laws, executive orders, corporate charters, implementing rules and regulations, prescribing salary grades for government officials and employees, except constitutional officials, have been repealed. As earlier stated, JR 4, adopted by both houses of Congress and approved by the President, is considered as law. It therefore follows that petitioners' reliance on Section 32 of RA 9173 has been rendered nugatory by subsequent legislative amendment and repeal and is thus misplaced. With this in mind, EO 811 could not have caused a diminution in the salaries of government nurses, as Section 6 actually raised salary grade of Nurse 1 from 10 to 11. The issuance of EO 811 fixing the entry-level salary of government nurses to salary grade 11 is a valid exercise of delegated power under Joint Resolution number 4, along with Presidential Decree number 985, as amended by PD 1597 and RA 6758, as amended by JR number 1. Pertinently,
Excuse me, are you reading the opening statement? Are you reading the opening statement that you have submitted?
that's why I asked for permission to
Yes, but
recast.
if you are reading, we will just interrupt you at this point. We will open the
Yes,
floor
sir.
for interpolation.
Yes, Your Honor.
Yeah,
May I
are you
proceed,
ready
Your
for that?
Well, as I said, Your Honor, I truncated some of the
Yes, I know, but
paragraphs.
if you are reading only, you may be ready already to answer our interpolation.
Right now, Your Honor.
Not yet?
Not yet, Your Honor. I still have
Okay.
3 pages.
You still have time anyway, but please, if you like to cut the time short, you can tell us, okay?
Yes, Your Honor. Thank you, Your Honor. The issuance of EO 811 fixed the entry-level salary of government nurses to salary grade 11 as a valid exercise of delegated power under JR number 4. Pertinently, the first resolving clause of JR 4 explicitly authorizes the President to modify existing compensation and position classification system of civilian personnel. In the same vein, Item 3B mandates the DBM to update accordingly its index of occupational services, position titles, and salary grades, a document listing the different occupational services, groups, series, and classes of positions existing in the government service, and laying out, among others, the salary grade assignments of each class of positions. These taken together show a clear, valid delegation of authority from Congress to the President by virtue of JR 4. Number 5, assuming that the joint resolution number 4 has not repealed Section 32 of RA 9173, the Honorable Court cannot compel the respondents to pay the nurses their compensation under SG 15 as prescribed therein. The Constitution mandates the President to ensure that the laws, including the provisions of the Constitution itself, be faithfully executed. It involves a twofold task, namely enforcement of the laws by him and enforcement of laws by other officers under his direction. It is thus a comprehensive function, and for its proper performance, the President is granted broad powers. Even assuming that JR 4 has not repealed Section 32 of RA 9173, respondents as alter egos of the President cannot be compelled to go against the Constitution itself, which states in Article 9B, Section 5, that Congress shall provide for the standardization of compensation of government officials and employees, taking into account the nature of the responsibilities pertaining to and the qualifications required for their positions. This constitutional mandate was carried out in RA 6758. In the law, it is the policy of the state to provide equal pay for substantially equal work and to base differences in pay upon substantive differences in duties and responsibilities and qualification requirements for the position. For example, as early as 1989, salary grade for nurse 1 was SG10. While the laws passed thereafter retained the same salary grade for nurse 1, the actual compensation increased by tranches. In 2002, the salary grade for nurse 1 was at SG10. It was 9,939. In 2009, EO 811 was issued pursuant to JR 4, increasing, among others, the salary grade of nurse 1 from SG10 to SG11. The salary then of nurse 1 at SG11 was 14,198. As of 2018, the salary of nurse 1 at SG11 is now 20,179. Assigning SG15 for nurse 1 position would lead to inequity and wage distortion in medical and allied positions, as well as other positions in the bureaucracy. A Nurse 1 would be higher or would be more compensated than a medical officer, i.e. a government doctor with salary grade 14. And this was in 1989. Furthermore, a nurse with salary grade 15 under provision of RA 9173 is considered higher than a pharmacist 1, SG 11, optometrist 1, SG 12, occupation therapist 1, SG 11, midwife 1, SG 9, medical technologist, SG 11, and dentist 1, SG 14. All of these allied medical professionals' work is under essentially the same conditions, but would become differently situated in terms of salary if Section 31 of RA 9173 would be enforced.
Will you please wind down? 1 minute.
Yes, Your Honor. On this score, Your Honor, one of the objectives of JR 4 per its whereas clauses is precisely to avoid the occurrence of wage distortions caused about by grant of benefits to selected professions under special laws. Such is the case here. The government recognizes the ever critical role of nurses in providing quality and accessible health care. However, the legislative intent to allow the executive branch to modify the framework for the compensation of civil servants in order to reduce salary inequities between government positions is clear and unequivocal. Ultimately, in the absence of any legal basis, Your Honors, respondents cannot be compelled to implement Section 32 of RA 9173. Thank you, Your Honor.
Interpellation to be started by Justice Carpio.
Thank you, Mr. Solicitor General. I have a few questions. What is the difference between an act that is a law and an act that has the force and effect of law?
Let me answer that in a simple manner, Your Honor. If a fowl looks like a duck, quacks like a duck, and moves like a duck, it must be a duck. So I will not go so much, I will not the differences between the two, Your Honor, because at the end of the day, they have the same effect.
Now, Congress passes a law, and the executive is required to adopt implementing rules. The implementing rules have the force and effect of law, correct? That's what all these executive rules and regulations are. They have the force and effect of law. Can those implementing rules amend the law, or any law for that matter?
Well, we're talking of implementing rules. It cannot amend the law, Your Honor.
So, implementing rules have the force and effect of law. But just because they have the force and effect of law doesn't make them law. Because to make them a law, they can now repeal prior laws, correct? Because only subsequent laws repeal prior laws. So, is there a difference between a law and one that has the force and effect of law?
Your Honor, if I may be allowed, may I read the position paper of the Senate and the House of Representatives, the conclusion part only, Your Honor.
Yeah, I know. They're saying their joint resolutions constitute law, but that's not what it's stated in their rules. The Senate rules say, if approved, a joint resolution has the force and effect of law, but they're now changing it to say a joint resolution, if approved, is law. Is that's their position now, correct?
Well, Your Honor, the Senate, may I just quote some sentences here, Your Honor. Under the rules of the Senate, the requirements and procedure for passing bills and joint resolutions are the same. Both bills and joint resolutions become law as long as they both undergo undergo the same legislative process required under Article 6, Section 26 and 27 of the 1987 Constitution and the respective rules of the Senate and House of Representatives. Being law, bills and joint resolutions may append or repeal existing law. Now, with respect to the
yes,
House, Your
okay,
Honor.
you don't have to read that. Now, under the Constitution, does the Constitution state that joint resolutions can become law?
Well, in the Constitution, the term there is bill, but it is a generic term, Your Honor.
So
as
anything
Justice Leonen said, the correct nomenclature should be Republic Act. It is an act of the Republic, Your
There are
Honor.
many acts of Congress. They can pass a report, Senate report that can be approved, and it can also be concurred by the House. Will that become a law? If they follow the procedure in the
It
Constitution?
becomes a law, Your Honor, and I'm referring to joint resolutions, Your Honor, because there are other
but
resolutions.
that's what I'm saying. It's not a matter of nomenclature, because if just anything can become a law if it passes through the same procedure, then a Senate report concurred by the House can become a law.
Well, according to our legislative branch, Your Honor, consisting of two houses, if the legislative course is followed for both bills and joint resolutions, they are considered law.
Okay, let's go to Senate Rule 23, Section 68. Do you have it?
I don't have it.
Senate Rule 23, Section 68.
Yes, Your Honor.
Yes, can you read it, please, the first sentence? The first phrase, Section 68.
Section 68. No bill shall be passed by the Senate unless it has passed 3 readings on separate days
Okay,
and printed
stop
copies
there.
thereof in its final.
Stop there. So no bill shall be passed by the Senate unless it has passed 3 readings on separate days. It says bills. It doesn't say joint resolution. Is there anything there in the rules that says no joint resolution shall be passed by the Senate unless it has passed 3 readings on separate days? Separate days? There's none.
You're referring again to Section 68, Your Honor?
Or any section under Rule 23.
Well, in Section 68, the second paragraph, it says here, and I quote, a bill or joint resolution filed as a substitute or a consolidated version of a bill or joint resolution previously certified by the President pursuant to Section 26, subsection 2, Article 6 of the Constitution shall likewise be certified for it to be considered for immediate enactment by the Senate.
If it's a substitute bill. But if it's not a substitute bill,
My point
if
here
it's a
is,
substitute joint resolution,
my point here, Your Honor, is that bill or joint resolution are the same.
yeah, but this speaks of a substitute or consolidated version.
By version of a bill or joint resolution.
Supposing there is none, there's no substitute, there's no consolidated version, so this will apply only to substitute and consolidated versions.
Well, the point here
What
that
I'm saying is that there is no provision in the Senate rules saying expressly that joint resolutions must pass 3 readings on separate days. There is no phrase separate days. It says
on 3 separate days, Your
bills
Honor.
and joint resolutions shall be read at least 3 times, period. Section 64. There is no provision separate days for joint resolutions. So it does not follow what's in the Constitution.
Well,
Unlike in the House follows the Constitution, the provision.
But in the first paragraph of Section 68, Your Honor, it says, no bill shall be passed by the Senate unless it has passed 3 readings,
Yeah,
etc.
only a bill. It refers only to a bill, not a joint resolution.
Well, in other parts of this rules, Your Honor,
Okay, can you just
Bill
discuss
and,
that in your memo, Solicitor General?
Okay.
Okay, my last question is, can a provision or a condition proviso in a General Appropriations Act amend or repeal a substantive provision in another law?
What is that other law, Your Honor?
Any other law? Can you
Well, the
discuss
civil
that in
code
your
says
memo?
that
Can
a
you
law can be
include that in your
repealed.
memo? We have already cases on that. Can you just discuss that?
Okay, Your Honor.
That whether the provision or a condition in a General Appropriations Act can amend or repeal a substantive provision in another law. Just discuss that in your memo.
Thank you, Your Honor.
Okay, that's all, Counsel.
Justice Hardalesa.
Mr. Solgen, a while ago you heard exchanges about the U.S. Constitution, right? To the effect that, and if you were following the discourse, the linchpin of the proposition that a bill is not a law is that the U.S. Constitution, from which we consideredly copied much of our provisions on the legislative power, apart from referring to bills, to a bill, the U.S. Constitution also refers to an order, a resolution, or a vote. You recall that a while ago, that was part of the conversation.
That's right, Your Honor.
But you have difficulty recalling it or focusing on it because that matter was not raised by the petitioners, right?
Yes, Your Honor.
And therefore, that is why I kept asking her that if, under our rules, if a matter on constitutionality is not raised, the court should not be taking that up.
Yes, Your Honor.
And I am stressing again that the reason it is important, the reason we have a rule that if there is an issue of constitutionality, it must be raised. And it must be the lis mota of the petition is that is not only a matter of procedure, but a matter of due process. Is it right?
Yes, Your Honor.
And it seems to me the best evidence is the reason you're not addressing it, this reference to the U.S. Constitution, you have not addressed it in your comment. You have not addressed it in what you submitted last Friday, is because it is only today, now, that you are hearing this for the first time. So I have issues of due process about why this court should even take you to task on the U.S. Constitution when that has not been raised at all.
Yes, sir.
But as they say, and once upon a time I was where you sit, you have to face the issues, right? Chief, with the permission of the Chief Justice, may I request one of my staff, Attorney Valdez, to distribute to the both counsels, to the petitioner and to the OSG. Mr. Soldian, may I proceed, Chief? So, The first page is a copy, direct quotation from Article 1, Section 7 of the U.S. Constitution. And you will see that it has 3 parts, right?
Yes,
it has
sir.
3, it has 3 paragraphs. Okay. The first paragraph is about all bills raising revenue. And I would request counsel for the petitioner to please follow the question so that when
Excuse me, I think the counsel is not present. Where is Attorney Paquis? She is forfeiting the right to be heard. Answering the call of nature. Will you please summon her so that there will be no complaints about fairness? Attorney Paquis, there is new material that is being submitted for your consideration.
May I proceed, Chief?
Will you please repeat for the
Yes.
benefit of Attorney Paquis?
Attorney Paquis, I just handed to you and to your co-counsel and also to the side of the government there's really just 3 pieces of paper. This is about the U.S. Constitution. I was telling the Solgen, and again, if I may repeat, the reason I was making a big point a while ago when I was asking you that you did not raise an issue of constitutionality is that, in fact, the Solgen have not taken up the matter of how we copied or how we did not copy or how we failed to copy the U.S. Constitution. Because as I said to the Solgen or to the government, you did not raise this, right? So now I'm having this short conversation and very short with the Solgen. So can you please follow, because I will also ask you to please validate whether what I'm saying now is correct in your memorandum. Do you understand? You can take your seat, please. Thank you. Now, Mr. Solgen, the second paragraph of the U.S. Constitution says, every bill which shall have been passed by the House and the Senate shall, before it becomes law, be presented to the President. Sounds familiar, right? Because if you read through, this is almost like the provision that we have, except that we have 3 readings on 3 separate days. But I call your attention, the second paragraph says bill. With the aid of your able ASGs, the second paragraph says bill, present to the President, does not mention resolution. Right? And yet, on the third paragraph, all of a sudden, and I placed it in bold, every order, resolution, or vote to which the concurrence of the Senate and the House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States. And before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and the House, according to the rules prescribed in the case of a bill. Right? Now, why do you think that after the second paragraph talks about a bill, all of a sudden, in the third paragraph, there is mention of order, resolution, or vote has to be presented, which is the subject matter of the second paragraph. Doesn't it strike you as odd? This seems to be, except for the use of the words every order, resolution, or vote, this is quite redundant. it repeats essentially the process, which in American constitutional law, you have to meet two requirements before you can have law, which is pass it bicameral, or what they call bicameral requirement. And number two, the Congress has to present it to the President, which he may veto. And they call it in American constitutional law the presentment requirement. Now, I go back to your question. And it is not fair to you because, as you said, you did not focus on this. But can you hazard a guess? Why is it that the second paragraph describes how a bill becomes law, and yet in the third paragraph, all of a sudden there is mention of order, resolution, or vote, and yet it just describes essentially the same process?
So my conclusion here, Your Honor, is a resolution is like a bill because it undergoes the same process, Your Honor.
And that is your conclusion based on your reading, right?
Yes, Your Honor.
Using logic and the structure of this argument. Now,
Yes, Your Honor.
again, and I direct also the attention of the petitioners, especially the counsel. Now, in your memorandum, please cover this point and tell me whether I am correct or I am not correct.
You are correct, Your Honor.
Thank you, counsel. Based on your logic.
Yes, Your Honor.
But I know because I came from your ranks once, that the people of the OSG, if you give them the idea of what is in issue, they know how to research. So if you do a little bit of research, you will realize that the issue of whether an order is the same, an order, a vote, or a bill are the same, has been passed upon since 1983 in the U.S. by the U.S. Supreme Court. And can you turn to page 2? That is the case of Immigration and Natural Service versus Chadha et al. Argued Feb 22, 1982, re-argued December 7, 1982, decided June 23, 1983. Now, I'm just quoting here one portion by then Chief Justice Berger, his opinion in this very, very leading case. And I quote, and can you please follow, and can the Petitioners' Counsel please follow? The records of the Constitutional Convention reveal that the requirement that all legislation be presented to the President before becoming a law was uniformly accepted by the framers, meaning the American framers in the Philadelphia Convention of 1877. Presentment to the President and the presidential veto were considered so imperative that the draftsmen took special pains to assure that these requirements could not be circumvented. Now, the next lines are very important. To ensure no circumvention, what did the U.S. the Constitutional Convention, do? And I quote, during the final debate on Article 1, Section 7, Clause 2, which is what you have with you, James Madison, we all know James Madison was one of the leading founding fathers of the U.S. Constitution. James Madison expressed concern that it might easily be evaded by the simple expedient of calling a proposed law a, quote, resolution or, quote, vote, rather than a, quote, bill. And then please check out the citation. It's 2 Farand 301 to 302. We all know, of course, Max Farrand was the famous Yale University professor who authored the 3-volume Constitutional Convention of Philadelphia of 1877. He is the equivalent of our Arwego. As a consequence, continues Chief Berger, Article 1, Section 7, Clause 3, that is now the one where it mentions vote, order, or resolution, was added to Farrand 304 to 305. So, in this case, the U.S. Supreme Court, more than 20 years ago, already explained why is it that there is such a thing as vote, resolution, or bill. In plainer language, kung isipin man ng lehislatura na magpakyut that anything that is legislative in character, they call by any other name, as you said, your appellation about the DAP, it's the same. Now, there is a further quote down the line by Chief Justice Berger, which echoes what Justice Alex Sismundo just said, and I quote, this is Berger, quote, an exercise of legislative power depends not on their form, but upon whether they contain matter which is properly to be regarded as legislative in character and in effect, end of quote. And in a quote that almost like captures the words of Justice Sismundo, a matter is legislative if, and I quote Chief Justice Berger, the Congress takes action that has the purpose and effect of altering legal rights, duties, and relations of persons. That's the civil code of counsel for petitioner. So, can you please cover in your memorandum whether my reading is correct or not? And I will invite also the counsel for petitioner to so cover it in her memorandum. Thank you, Chief.
Justice Marvick.
Good afternoon, Counsel.
Good afternoon, Your Honor.
Let's go to the remedies first. So, mandamus cannot be a writ that is general, such as we cannot issue a writ of mandamus to the President to implement the law, correct?
Yes, Your Honor.
Because that is already covered by his oath under the Constitution, correct?
Correct, Your Honor.
In other words, for us to issue mandamus, it has to be specific. And as far as I can read the petition of the petitioners, they want a writ of mandamus either of two things. One is to compel the DBM to recommend salary grade 15, and the other one is to compel Congress to appropriate. Using the principle of charity, I will remove the second, and perhaps the mandamus would be for the DBM to recommend in the National Expenditure Program salary grade 15. Is that correct? But that cannot be done because recommending a budget is not the prerogative of the Supreme Court, correct?
That's right, Your Honor.
It's the prerogative of the President in a National Expenditure Program or the NEP, correct?
Yes, Your Honor.
And therefore, it is not within our jurisdiction, correct?
Correct, Your Honor.
Yes. So, if there is a commitment in a Republic Act for a particular salary grade, it is a legislative aspiration only, correct?
That's right, Your Honor.
Because any commitment of any fund in an ordinary Republic Act to complete the vesting of that right, it must also contain a separate appropriations, either in the same Republic Act or according to the Constitution in an appropriations bill. Is that not correct?
That's correct, Your Honor.
And that is so because there is a separate provision in the Constitution which requires that all expenditure of public funds must be through an appropriations act, correct?
Correct, Your Honor.
Whether the general or special or supplemental ones, correct?
Yes, Your Honor.
Yes. Therefore, in a sense, any statement committing funds in a Republic Act, a General Republic Act, is not complete in terms of its effectivity until there is an appropriation. Is that not correct?
That's correct, Your Honor.
Therefore, it is in the form of a legislative aspiration only, correct?
Yes, Your Honor.
And therefore, to complete it as a vested right, there must be an actual appropriation of a particular amount relating to the salary grade. Is that not correct?
That's correct, Your
Yes.
Honor.
Okay, let's go to a second point. The President is given salary grade 32. Am I not? Am I correct? The
Yes, Your
highest.
Honor.
It's salary grade. I'm sorry, 33. With apologies to the
33.
President, he has a higher salary rate. Salary grade 33. That is equivalent to a certain amount, correct?
Yes, Your Honor.
Congress, in its wisdom, can change the salary grades and make it salary grade 40, adding 7 more salary grades. Is that not correct?
That's a possibility, Your Honor.
With, for so long as it does not diminish the amount that the President has been receiving. Is that not correct?
That's correct, Your Honor.
Because the salary of the President cannot be diminished by a particular term of Congress. Is that not correct?
Yes, Your Honor.
The same with the judiciary, correct?
Yes, Your Honor.
So when we speak of non-diminution, it means the actual money that we receive as members of the court or the President or Congress receives. Is that not correct?
That's right, Your Honor.
Except for Congress, it's the reverse. Congress cannot increase its salaries within its terms, correct?
Yes, Your Honor.
It does not refer to whether it's salary grade 15, 15 and a half, 15 and 3/4, or salary grade 11. Is that not correct?
That's correct.
What
Your Honor.
matters is the amount that is being received, correct?
That's right, Your
And under the fourth tranche now, in this current Appropriations Act, a nurse one will not be receiving 4,000 pesos anymore,
No,
not
no.
11,000, but nurse one under salary grade 11, step 1 is about 20,000 pesos. You can
more than
check
that, Your Honor.
Yes, 20,000 something.
Yes, Your Honor.
Correct. So in other words, that is the concept of non-diminution. Now, the Department of Budget and Management, when it funded Executive Order 811, when the President issued Executive Order 811 also, they had the impression that the joint resolution was law. Is that not correct?
Yes, Your Honor.
They had that impression not only because it was signed by the President, but also because it was passed by 2 chambers with 3 readings. Is that not correct?
That's correct, Your Honor.
Now, for them to see it in that manner is not abuse of discretion even. Certainly, it is not grave abuse of discretion because there was sufficient ambiguous legislative situation, and to their best of their knowledge, they thought that Joint Resolution number 4 was law. Is that not correct?
That's correct, Your Honor.
And because it was not capricious or arbitrary, it was discretion on their part. Certainly, they looked at it from their point of view, but it cannot be grave abuse of discretion. Is that not correct?
Yes, Your Honor.
Therefore, certiorari cannot lie, correct?
Correct, Your Honor.
Okay. I go to a second to the last point. If you and I became senator or run for senator, I am sure that both of us will want salary grade 30 or higher for working nurses. Is that not correct?
I have no political ambition, Your Honor, but
Yes, but
you're
if you and
correct.
I will run,
Yes.
dalawa diretso ang tawag natin. Okay? We would want salary grade 30, the highest possible, if that's possible, correct?
Yes, sir.
But right now, for us in the Supreme Court, that would be irresponsible because we cannot see the entire lay of the land. As you have presented in your table, it will affect Medical Officer 1 and several other positions. Is that not correct?
That's correct, Your Honor.
Therefore, by constitutional mandate, we are not to go into the wisdom of the distribution of monies collected by government. Is that not correct?
Yes, Your Honor.
And therefore, if we read grave abuse of discretion, we have to take this into consideration, whether the consequences of what we will do would be reasonable or unreasonable. Is that not correct?
It's correct, Your Honor.
Yes. And finally, the point of the Constitution is that when something becomes law, it goes through the proper deliberative channel in the 2 chambers in a transparent manner, participated by those that have been elected. Is that not correct?
That's correct, Your Honor.
Yes, and whatever it comes out with, whatever name it is given, for so long as that is respected, then therefore it will become law or the force and effect of law. Is that not correct?
It's correct. Your
Yes. Would you agree with me that there is nothing in the petition which alleges a fundamental right that has been violated in terms of citizens, and that there has been no allegation of any shortcuts in the procedure that has been committed by either house in terms of passing Joint Resolution Number 4?
I agree 100%, Your Honor.
Yes, and therefore, it is not our role to look for that breach, although we may want to, because it was not raised properly by the parties. Is that not correct?
Yes, Your Honor.
Yes. In other words, perhaps it may be wrong for the public to think that we do not want nurses to be properly compensated. It is just that we want them compensated properly under the banner of the rule of law. Is that not correct?
That's correct, Your
And
Honor.
that is also the same for the Solgen.
Yes, Your Honor.
Yes, thank you.
Thank you, Your Honor.
Justice Kagiwa.
Thank you, Chief. Mr. Soljan,
Yes, Your Honor.
before JR number 4 became a law, it was the consolidated version of Senate Joint Resolution 26 and House Joint Resolution 36. Is that correct?
Yes, Your Honor.
Can I ask my staff to flash on the screen? Okay. In turn, Senate Joint Resolution number 26 is actually a consolidated version of several resolutions and bills filed by members of the Senate, as well as HJR number 36 is also coming from several joint resolutions and House bills. Can you confirm that that is my research?
Yes, Your Honor.
So in all of those consolidation, we're really talking also about a lot of measures that are called or originated as bills.
Probably, Your Honor.
So let me just restate what I think you said based on Section 16 of the Constitution. If a joint resolution undergoes the constitutionally mandated legislative process, then it is considered a law, correct?
Correct, Your Honor.
And if a joint resolution does not follow the required legislative process, then it is not a law, correct?
Correct, Your Honor.
If a bill undergoes the required legislative process, it becomes a law, correct?
Correct, Your Honor.
If that same bill does not follow the required legislative process, then it does not become a law, correct?
That's right, Your Honor.
So this legislative process, which is found in the Constitution, is actually defined by the Constitution and not by Congress, correct?
Yes, Your Honor.
So even if Congress, the Senate, or the House were to subsequently change their rules and provide that joint resolutions can only can be issued on the basis of one reading on only one day, those rules will be irrelevant because it is the Constitution that mandates what the process is for a legislative measure to become law, correct?
Correct.
So we take our bearings always from the requirements of a legislative process under the Constitution, correct?
Yes, Your Honor.
That's all, Chief.
Thank you, Your Honor.
Justice Carpio. Okay, Justice Del Castillo.
Chief, just two questions.
Three. I will give you three.
Mr. Soljan, can Congress delegate to the President legislative power?
Come again?
Can Congress
Delegate
to the President
under
its
certain
legislative
principles and guidelines? Yes, Your Honor.
As a matter of fact, it just did with the passage of JR 4.
Yes, Your Honor.
But doesn't the Constitution provide that appropriation power is exclusively lodged with Congress?
Well,
The power
Congress
of
is the-
appropriation
Yes,
is
yeah.
exclusively lodged with Congress.
Yes, Your Honor.
Why are you saying now that Congress can delegate its appropriation power to the President? Because that's what exactly it did. Because when Congress authorized the President to modify compensation and minimum base pay, it in effect, because it entails the release of public funds, isn't it? Which is power of appropriation.
Well,
And so how do we reconcile that now with this provision in the Constitution that the power of expropriation of appropriation is exclusively lodged in Congress?
Under Joint Resolution Number 4, Your Honor, it is a resolution authorizing the President to modify the compensation and position classification system of civilian personnel and the base pay schedule of military and uniformed personnel in the government and for other purposes. So this has been done. This is not the first time that the authority authorizing the President to modify compensation was passed. There was previous joint resolution before, Your Honor.
What I'm just saying is I'm a little, I find it a little difficult to reconcile that with the constitutional provision that the power of appropriation is exclusively lodged in Congress.
Yes, but Congress can also delegate, Your Honor, provided under the Abacada versus Purisima case, Your Honor.
Sufficient standards are set.
Yes, there's completeness test and sufficient standard test.
Okay. Thank you, Counsel.
Thank you, Your Honor.
Carpio.
Counsel, can you read paragraph 1A of our advisory?
Yes, Your Honor.
Yeah, can you read it? 1A.
1A. Yes, Your Honor. Whether Joint Resolution Number 4 has repealed Section 32 of our Republic Act Number 9173, Number 1, whether a joint resolution that followed the procedure of a bill passing into law is a law. Number 2, whether Joint Resolution Number 4 followed the procedure of a bill passing into a law.
Okay. That procedure is stated in Section 27, Article 6 of the Constitution, correct?
Yes, Your Honor.
No bill shall be passed unless it has passed through 3 readings. So in other words, the question is whether Joint Resolution Number 4 is the law that is referred to in Section 27, Article 6 of the Constitution, requiring certain procedures, correct? That's the issue here that we are asking you to discuss.
In our memorandum,
Yes.
Your Honor.
In
Yes,
other
Your
words,
Honor.
the frame of reference in this oral argument is Section 27, Article 6 of the Constitution, because we cannot decide this case without determining whether Resolution Number 4, Joint Resolution, is a law or not. Because if it's a law, then it repealed, as is your position. If it's not a law, because it's not a bill, then it cannot repeal, correct?
We will discuss that, Your Honor,
Can you
in our
discuss that?
memorandum.
Okay, my second question is, well, the U.S. Constitution has 4 acts that can become a law. Bill, resolution, vote, order, correct? What have we adopted in the 1935 Constitution?
We will also discuss that, Your Honor, in
No,
our
I mean, my
memorandum.
question is, you can answer it now. Of the 4, what did we adopt? We adopted only bills.
The terminology is bill, Your Honor.
Bill. So can you discuss the effect of that? Why did we junk the other 3 and adopt only bills? And not only in the 1935, also in the 1973 and 1987 constitutions. Why did we not adopt the other measures that are stated in the U.S. Constitution? Now, discuss that in your memo. That's
Yes.
all, Counsel.
Yes, Your Honor. Thank you.
Okay. Let's go back first to Justice Ardelesa.
Yes, just one more question to the Soldian, and I'm also directing this to counsel for petitioner, please. I'm sorry I missed, as I said, there are 3 pages in the handout that I gave to both sides. The third page is a reference to the Jones Law of 1916, Section 19. Well, as we remember, the Jones Law was the organic law where we were given by the U.S. Congress the Constitution. Now, Section 19 set out there is the legislative power under the Jones Law. Now, I put in bold, it says bill and resolution. Now, this is 1916. The U.S. Constitutional Convention in Philadelphia was 1787. So, if you do a simple math, the Jones Law is 129 years after the U.S. Federal Constitution. Again, I will ask you, why do you think that the U.S. Congress, when they gave the Jones Law, mentioned bill and joint resolution? When they were proposing our Constitution, why is it that they did not mention the word order, as can be found in Article 1 of the U.S. Constitution? Why do you think that they did not mention the word vote? Why of the 4 mentioned in the 3rd paragraph of their Constitution, why did the U.S. Congress deign to mention only 2 terms? I do not have legislative history for that, but my humble submission to you is that 129 years after the Philadelphia Convention, it became already accepted in the U.S. that a bill is like a resolution. That is why when the U.S. Congress passed the Jones Law, they thought about bill and resolution. At hindi na nila inulit yung order or vote. Can you please cover that in your memo? And I would welcome very much a possibly contrary view from the petitioner if you can, you can go into legislative history of the Jones Law. Thank you.
Thank you, Your Honor.
Justice Karandang.
Mr. Soldier, I only have 2 questions. You said earlier that this is not the first time that something like this happened.
Yes, sir.
That an authority was given to the president to classify or modify the pay structure of the people in government. When was the first time?
There was this joint resolution number 1 during President Fidel Ramos's time.
And there was no case brought up in
None
regard
that
to
I
this
know, Your
case? There is no case that
None
was
that I
brought
know, yes.
questioning this one, the joint resolution number 1, authorizing the president to
None, Your
modify or classify positions in the government service. Has there been a case?
No, Your Honor.
There's
To my
none.
knowledge, none.
Okay. You said that this is a valid delegation of legislative power to the president.
Yes, Your Honor.
So there are standards to make this delegation not an undue delegation of legislative power.
That's correct, Your Honor.
Can you please state what are these general standards?
It's in the joint resolution itself, Your Honor. It says here, whereas in order to make the present compensation and position classification system and base pay schedule more effective in motivating government personnel and in invigorating public service, reforms in the present system and pay schedule need to be instituted. Now, therefore, be it. So, okay. As I mentioned earlier, Your Honor, in my opening statement, JR4 validly delegated to the President the power to modify the compensation and position classification system because it passed both the completeness and sufficient standard tests. We are citing here the jurisprudence Abacada versus Purissima. It is complete because, as stated in the whereas clause, the policies to be implemented are to make the present compensation and position classification system
Uniform.
more effective and to reform the present system and base pay schedule, considering the distortion brought about by inequitable salaries. Moreover, item number 16 expressly repeals all provisions of laws prescribing salary grades for government officials and employees other than constitutional officers. It has sufficient standards because item number 1, the governing principles found in JR4, sets forth adequate guidelines or limitations in order to map out the President's authority. So,
in the first place, when Congress passed this joint resolution, they were aware that there are, in the standardization plan that they crafted before, there is a default or distortion in the base pay of
Yes, Your Honor.
several government employees. And
Yes.
they recognize that.
we will explain that in our memorandum, Your Honor.
And that's the reason why they resorted to passing this joint resolution number 4.
Yes, to correct the errors and the distortions in the salary wages, Your Honor.
Can you please expound that in your memorandum,
Thank you, Your
Mr.
Honor.
Solicitor General?
Okay, it seems the oral arguments are already done. We will require the parties to submit your written memoranda within 20 days. You incorporate everything that you were required by any of the justices in the course of the interpellations to submit or to argue on. All right. That is a non-extendable period of 20 days from today. That starts tomorrow. Okay, no other matters? No other matters, petitioner? No other matters, respondents? None?
Thank you, Your
Okay.
Honor.
The session is hereby adjourned.